All right. All persons having business before the Honorable Columbia Judges, now presiding of the District of Columbia Court of Appeals. Draw near and give your attention. God sent the United States and this honorable court. This honorable court now in session. Please be seated and come to order.
Good morning and welcome to the District of Columbia Court of Appeals. We have 3 cases on our calendar this morning. The first case is 22 CF 85, Joshua C. Austin versus the United States.
Good morning. May it please the court. My name is Cecily Baskier on behalf of appellant Joshua Austin. I'd like to reserve 2 minutes for rebuttal. Emily Marvel's statements to the 911 operator should not have been admitted at trial under either the Confrontation Clause or as exceptions to the hearsay rule. Because their admission was not harmless, this court should reverse Mr. Austin's convictions. I'd like to start this morning with the hearsay issue because the court doesn't have to reach the Confrontation Clause if it agrees that the statements should have been excluded under the hearsay rule.
But if we don't reach the Confrontation Clause issue, then you're leaving the more favorable harmless error standard on the table. Is that correct? Are you giving that up?
Not giving it up, Your Honor. I believe that the admission of the statements is prejudicial under whatever standard the court decides to review it under. And I'm certainly happy to speak about the Confrontation Clause as well and identify the harm, again, under whichever standard. But yes, there's a more favorable standard for the constitutional error than there would be for hearsay. So beginning at least with the hearsay issue and then turning to the Confrontation Clause shortly. The fundamental problem with the trial court's hearsay rulings is that it improperly expanded the bounds of the excited utterance in the present sense impressions beyond what this court permits. So first, for excited utterances, the trial court said that it is too narrow to require that someone be in hysterics or be crying, showing that level of excitement. But if not hysterics, this court at least does require some higher level of emotional upset than what we have here with some verbal strain.
So how much does your argument depend on, I mean, are you suggesting that we can accept all of the trial courts, I guess their findings of fact, maybe you would disagree with that, with respect to Ms. Marvel's underlying stress level and indications of that stress level, heavy breathing and seemingly out of sorts and all of that, and you are still right on this, or or do you think we don't owe those findings the normal clear error deference that they would get because we can listen to the recording just as well as the trial court did?
So, Your Honor, even accepting those findings, they're not going to meet the legal standard of what this court has required under Odoms and Mahan and
That doesn't quite answer Judge Shanker's question. Do you think that we're bound by the findings, or do you think that we can listen to the recording ourselves and make our own assessment? And if that assessment differs from the trial court's assessment, we can rely on our own assessment.
So the court certainly can listen to the recording and has observed that in other cases. It does owe deference, but that deference is not unlimited. And so if the record shows that there is clear error in the findings, the court does not have to defer. I think here, when the court does listen to the recording and also considers what the statements are that are being made, even without hearing the tone, the record shows that those findings, or several of the findings, are clear error, but that's not necessary in order to rule in Mr. Austin's favor on the hearsay issue. So the short answer is yes, there's clear error, and the court can recognize that clear error based on listening to the recording. But it can also find that even accepting the findings, and particularly the findings where the court is saying—
I mean, the court says that the call is a stream of consciousness dump. Do you think that that's a fair characterization of the 911 call?
I do not think it's a fair characterization of the call. And I think, again, the court can find clear error in that characterization. But even if it is a stream of consciousness dump, it is not one that is manifesting the level of excitement that this court requires to find that someone has suspended their powers of reflection.
Oh, I mean, why not? I think you would agree with me that people can mask their emotions, right? Just as somebody could be screaming things that they're in fact quite calm and deliberate about, they could quite calmly be stating things that they are sort of in a state of disarray about. So if in fact these were non-responsive to the operator's questions, which is a factor we've said can favor finding that it's an excited utterance. If she just seems to be meandering in her thought process, but doing so in a calm tone, are you saying that that couldn't be an excited utterance because tone is sort of the dispositive factor?
Tone isn't necessarily dispositive, but it's extremely important, particularly again, where we do actually have a recording to listen to be able to recognize clear error if we want to. But
What if Ms. Marvel had been available as a witness and testified? Yeah, I recognize that I sound sedate on that phone call, unexcited. But let me tell you, I was in a fugue state. I've blacked out. I totally don't even remember what was happening. I was so distressed. I think you would have to agree that a trial court could find that it was an excited utterance if met with that testimony, right?
So, Your Honor, I'm trying to first process whether the trial court would be able to consider that, because of course there's sort of, at the time that it's making the ruling, it wouldn't have that information from her because it's a pre-trial ruling.
It could.
But,
I mean, yeah, you can do a motion in limine. I think, parties often lay the basis for getting their hearsay in. Before you admit this as an excited utterance, Your Honor, outside of the hearing of the jury, we would like to test what the foundation is. And then you ask her and she says, I was more excited than I've ever been in my life. And just as a personality trait about me, when I'm very excited, I sort of default to staid and steady and sedate tones. And she brings in 5 witnesses who say, yes, I've seen her excited, and she acts that way. That would support an excited utterance finding, right?
I think, Your Honor, it probably would, but that's certainly a very different set of facts that the court would be dealing with than what it has here. And when we look at this court's case law, even though it regularly quotes the language saying nervous excitement or physical shock, it has never developed any standard that is different for shock. And so whatever shock may be and whatever it may look like in a person, this court has said, and it said also, there's a footnote 5, I believe is in Odom, the necessary element for an excited utterance is a state of excitement. And just labeling something shock where we don't know what colloquially the trial court means by that. Are we talking the kind of shock that they were describing in Brown? Are we talking medical shock? We don't know what it means, but simply labeling something as shock and saying, well, that's enough to not have to follow what the court has said in Mahand or Gabra-Medin or Pelzer or any of those other cases, I think just opens up the door to letting in many things under this exception that this court has indicated in the past that it does not intend to accept as exceptions to the excited utterance.
Can we get back to the confrontation clause?
Yes,
I
Your Honor.
mean, do you want to tell us why you think this statement was testimonial?
Yes, Your Honor. And I'll break it out into 2 categories. First, from her perspective, or from the perspective of an objective person in her shoes, saying what she is saying, knowing what she knows, and saying it the way she is saying it at that time. The primary purpose is testimonial because when she's making these statements, she knows that she is at home. She believes that he is gone, because that's what she says. She does not know who he is and doesn't have any reason that is at least reflected in what she says or how she says it to think that he may still pose some harm to her in her apartment.
Well, so let me pause you on something. You said she didn't know who he was.
Mhm.
And I think that was clear in the call that she wasn't trying to identify the perpetrator of this, at least not until she was asked directly by the 911 operator. So I get she might have been trying to report some crime, but not so much in the sense of bearing witness against a particular person, which is really kind of the core of the confrontation clause analysis, isn't it?
I think, Your Honor, she says she wants to report that. And what she's doing is she's answering the questions as they're coming to her from the operator, but she is not showing any primary purpose of wanting to respond to an emergency, or at least an ongoing emergency. She is not blurting out in the beginning that she needs the police, or she needs help, or she wants ambulance, or she's afraid, or any of those things that characterize non-testimonial statements that we've seen in other cases involving 911 calls.
Yeah, I mean, those are all indicia of non-testimonial statements, but we might be flipping the analysis, right? I mean, the question is, was she bearing witness against the person who ultimately ended up at trial? And when she has no idea who did this, she was not trying to point this out to the police. So-and-so did this to me. She was just reporting a crime. Have we flipped into testimonial as opposed to just being maybe non-testimonial? Do you see what I'm saying?
I think so, Your Honor. And I think that that it has flipped into testimonial, because bearing witness is not limited to it was Mr. So-and-so who did it, or I'm trying to identify the person. Bearing witness can include, I believe, other circumstances around what happened to allow then the police to do their investigative work, and then the government to do their prosecutorial work to then actually find that person and bring them to justice. So I think it's possible to be bearing witness even if the first things out of your mouth are not, this is the person's name, or this is what they looked like. And here, she thinks that he's gone. She knows there's no weapon used against her. She's not asking for medical assistance, I think. And she says she just wants to report that. So looking at those number of factors, at least from her perspective, we see that she's not perceiving an ongoing emergency. And if the court finds itself in equipoise, because this is the government's burden, even if it thinks that from the operator's point of view, there's an ongoing emergency, and I'll turn to reasons why it shouldn't believe that. But even if it accepts what the trial court said, okay, there's an ongoing emergency potentially from the point of view of the operator, if the court does have to look at both perspectives, if it's in equipoise, then the government hasn't met its burden of showing that the primary purpose is not testimonial.
I'm really curious about what that means, looking at both sides. So let's take I want you to help me understand like whose perspective really matters when looking toward the primary purpose of the phone call. Let's take somebody who had been shot 5 days earlier, and they call 911 and they say, "Operator, I've been shot. And this is the person who did it," and it gives no indication that it happened 5 days ago. Clearly not an emergency situation from their perspective, but pretty clearly an emergency situation from the operator's perspective. Which perspective controls in determining whether or not that's testimonial?
Well, I think the case law to this point, and the Supreme Court has not been clear on that. It's been clear that both control. And at one point, we were being told that it's the declarant's perspective that's going to control. And then we're saying, well, we have to consider both. I think that ultimately, because we're talking about the testimonial nature or non-testimonial nature of the declarant's statements, rather than being primarily concerned with the statements being made by the interrogator, I'd say that when push comes to shove, if you have to put more weight on one or another, it makes more sense to put weight on the primary purpose being made by the person speaking.
I agree with that. Do you think that's what the case law bears out? I mean, that sounds definitely contrary to Justice Thomas's view that, this is all about the Star Chamber and they're bringing witnesses in to create evidence. And we're concerned with sort of state creation of evidence. And that's really what the Confrontation Clause is about. And I really don't remember. And I haven't been able to find a good answer. If your answer is it's unclear, okay, that aligns with my memory. If you think there's something I can read that will give me some clarity on it, though, I would love to hear what that thing is.
I think that it is unclear I think that Justice Scalia was clear in the decisions that he wrote that the declarant's perspective is going to take precedence. I think it's been muddied a bit since Michigan versus Bryant. However, when we look at the facts of that case and we look at the facts of other cases, I don't think the Supreme Court or this court has confronted any situations where there aren't a lot of indications that the speaker's primary, the declarant's primary purpose is also to respond to it.
So would it be fair to say that in the cases thus far confronted, the speaker and the interrogator's purposes have been more or less aligned?
Yes, Your Honor.
And if they were to disalign, you would still primarily look at the speaker's purpose?
Yes, Your Honor. And I think another way of looking at it, let's say they disalign in the other way, where it very much looks like the interrogator is treating this testimony in a testimonial way and the speaker is not, then I think you can also look at it in terms of the government's burden. They have to prove that it is not testimonial. So if you're left with one person goes one way and the other person goes the other way, then it is no longer, it's not more likely than not a non-testimonial purpose.
So I have some questions about harm unless my
That's where
colleagues
I was
want
gonna
to,
take us. Yeah.
well, feel free to take us away if you have a question.
I was going to ask you to speak to harm, and in particular, harm vis-a-vis the assault conviction.
Yes, Your Honor. So the assault conviction is an assault with intent to rob conviction. So one of the elements of that is intent to rob. Without the 911 call, there is no evidence of a robbery. And that speaks not only to the robbery charge, but also to the intent to rob elements of the burglary and the assault charges, because there is much less there. We don't even know that a robbery has occurred. We don't have her statement that he was angry when
Well,
she
the
didn't have
intent
a
to
wallet.
rob would have developed before the actual robbery, right? And could have existed without an actual robbery. And so, I mean, the footage of him watching her closely in the store, watching her take the money out of her purse and then basically following her home and then closely following her into the building and then leaving shortly thereafter. Well, I don't even know if you need the last part. I mean, wouldn't that satisfy intent to rob? And I mean, you agree all of that comes in, right?
So I agree that that all comes in, and that if we're looking at this for sufficiency of the evidence, then yes, probably there's sufficient evidence to be able to bring this to the jury, but that's not the standard here. We're trying to look at, is it highly probable that the jury would have reached the same verdicts? So even if there's circumstantial evidence that could support intent to rob, the question is, would the jury highly probably still have, and that's sort of looking under the Kodiakus standard and Chapman, it's going to be an even harder burden for the government to overcome. Is that enough, given that if you a reasonable jury, if they're only seeing video evidence showing proximity at the market and proximity in the building, there's fingerprint evidence of Mr. Austin's prints, but also some unidentified person's prints. And you've got evidence that strangers come in and out of the building through the basement where no one has looked at the cameras to see if there was anyone there. A reasonable jury could find reasonable doubt in the government's case that this was actually Mr. Austin attacking or intending to rob her there, rather than him either interrupting someone who has assaulted her as soon as she's walked in, and then he tries to help her and panics and flees. Or maybe there isn't even an assault in the first place. She has fallen, she becomes confused. He's trying to help her. She thinks that he's not trying to help her. He runs out. There are a lot of questions that are there that a jury could think about, and that defense counsel would hopefully be arguing very vehemently in closing.
I mean, what's a little bit odd about that is there is no defense theory that she wasn't assaulted, she wasn't robbed. The defense is, well, yeah, she was assaulted and she was robbed, but it wasn't Mr. Austin. So that's the defense theory. And one thing that you do in your harm argument is you say, well, look, if they hadn't admitted this 911 call, the defense would have played out very differently. They would have oriented their case along a different lines. They wouldn't have introduced, opened the door to rebuttal testimony, providing identification evidence independent of the 911 call. And I wonder if that's an appropriate way of thinking about harm. And you don't cite to any cases that suggest you look at the downstream effects of how a piece of evidence affected a party's decisions in the trial. And I'm not sure if that's appropriate to take into consideration as opposed to kind of stripping out the harm, looking at what's left and saying, well, and that would become much harder for you because you could say, well, the 911 call didn't really have a lick to do with identification. They got identification through fingerprints, through video surveillance. The 911 call, all it established really was that an assault and a robbery occurred. Those are uncontested facts that the defense never sought to dispute. So how could that have mattered? Which is the right way of looking at it, do you think? I mean, do you have any sort of support for thinking you can look at how an error, how its downstream effects on the parties and how the parties litigated their case can be taken into account in the harm analysis?
I will do my best, Your Honor. So I think one thing that's very significant here is when the error occurs. If the error is occurring months before trial, so everyone's going in knowing this is coming. And this is not a witness is speaking, defense counsel says objection, hearsay, they figure it out on the spot and go from there, where the trial has, one can kind of assume that, but for the witness starting to say that hearsay, everything else would have played out the same way. I think there is some case law, though not directly on point, in 2013 case Jenkins, the citation, which I don't have, but I can supply.
It's one of our cases.
This is one of our cases. And it's basically a situation, I think it's footnote 26, where the court talks about defense counsel trying to make the best of a bad situation. And sort of once they're, again, it is not directly on point, but it is this idea that the court shouldn't be assuming, I think 100% that defense counsel is going to act the way they do in the face of a bad situation from a ruling from the court if the court had not made that incorrect ruling. So again, it's not directly on point, and I wish I could point the court to cases. I think that this situation in my research, I have not found comparable circumstances where the court has been clear one way or another, but it seems to me a very reasonable approach that if you conceive of the error as the decision to admit this call in its entirety before trial, defense counsel then has to do the best they can do to develop a theory and a defense, assuming this is all coming in. And if you try to strip away the harm and see what's left, it's just a messier job of trying to do that. But I can't imagine any objectively reasonable defense counsel opening the door to bring in a description from the witness of the assailant that isn't otherwise there when you have a defense of this guy was innocently present, he's not the one who did it.
But even aside from defense strategy, though, I mean, correct me if I'm wrong, maybe I have the record wrong, but I seem to recall government direct testimony from police officers and the EMT, although maybe different on that, that implicated your client. I mean, and there were no hearsay objections as far as I recall. So why aren't we just looking at that?
So I think, Your Honor, the police testimony, I think there are two, maybe three things that one could conceivably think of. First is the redirect examination testimony of Officer Davis, where he gives the lookout. That's the one where the defense opened the door to it in cross-examination by saying, do you remember the lookout? And that's the one where I'm saying would not reasonably have come in otherwise. Detective Pugh on cross-examination says that she says she's pushed from behind, so she doesn't see who did it. I wouldn't say that that is particularly, maybe that supports the idea of an assault, but again, a defense counsel, if that's all they're working with, is going to say, she's this old frail lady, you know, with long-term illnesses, who knows if she's actually pushed, if her recollection is accurate or not. And I think Officer Dengler says something about having a lookout involving a person with a bicycle. And there's no hearsay objection to that at trial. But again, had the 911 call been kept out, I think one can assume reasonably that defense counsel would not have wanted any description coming in and would have had there's sort of no reason not to make the hearsay
Well, I mean,
objection at that
I
point.
actually think there is a reason not to make the hearsay objection there, probably because it's not hearsay, because the government would have said it wasn't being offered for the truth of the matter asserted, but for the effect on the police officer and why the officer engaged in the investigation that he engaged in. But that begs the question, what we can consider it for, but
Mhm.
in any event.
But I think I want to sort of come back to what I think maybe sort of is at the heart of this, which is that even that the government used this case or used this call, sorry, a lot. And it's the only direct evidence that the jury heard of what happened in the stairwell. And the government acknowledged that at trial, said that it was providing crucial details, filling a gap. And they want the jury to hear her voice. They say, listen to it in Emily's voice. And I don't think this court should underestimate the tremendous emotional impact on a jury of hearing a victim who's otherwise not present there, describing her attacker and saying what happened. And in trying to strip away the error, I think the court does need to consider that impact on the jury, in addition to what could they have done with the circumstantial evidence without hearing her frail yet calm voice saying the guy on the bicycle did it and he took my money and all of those things.
Thank you, Ms. Vasquer. We've kept you up here over your time. We'll hear from the government now and we'll give you a few minutes in a rebuttal.
Thank you, Your Honor.
Thanks.
Morning, Your Honors. May it please the court, Catherine Kelly on behalf of the United States. Just to be clear, since we've been talking about it most recently, the defense counsel made a calculated decision to get into Officer Davis's recollection of what the description was that Ms. Marble gave him when he arrived to speak to her at her apartment after the robbery. And he made clear, pages 126 and 127 of the December 9th transcript, that he was bringing in this lookout information, or the fact that Officer Davis could not recall any of this information, to show that once again, this was sloppy police work. This officer didn't even bother to prepare for trial, because when you started to question him about, do you recall what she said specifically, he was saying, I don't recall this detail. I don't recall
But the
that detail."
sloppy police work defense theory is being pursued after the 911 call has already been deemed admissible, right?
The sloppy police work theory was consistent throughout trial. That was a
Sure,
large
but
aspect.
the 911 call at this juncture has already been deemed admissible,
Yes, that was a
Yes.
trial decision.
right? So can we talk about why the government thinks it is admissible, why the government thinks that it is not a testimonial statement?
It's not a testimonial statement, Your Honor, number one, because it's a perfect example of a 911 operator trying to ascertain objectively whether or not there's an ongoing emergency.
Are you
What's
saying
going
that the
on?
911 operator is trying, that we can attribute that purpose to the 911 operator because the 911 operator asks, what's the location of your emergency?
He's asking a number of questions.
I mean, I guess my question to that is, does the 911 operator ever ask a different question at the beginning of the phone call?
It's a very common question that I've personally heard many times. However,
Right.
that does
But
not. turn
people
it into
call
a
911 for all manner of reasons, right?
Right, but you're still ascertaining what's going on, which after he gets the initial, where are you information, he asks immediately then, what's the nature of your emergency? He's
Okay, but
trying-
then does that, I mean, what's the limit of the government's argument? Does that mean that every 911 call is a non-testimonial statement?
No.
Because the operator is asking, what's the nature of your emergency at the beginning of the call?
No, we're not saying that, but it's clear from these questions that he is just trying to figure out what happened as
Right, so the
Brian,
first-
Tyler,
The
Petit.
first minute of the call is just getting information from Ms. Marville
Right,
at a rather slow pace. I mean, what's your address? What's your phone number? What's your name? She takes the time to spell it out. And we're at minute 103 by the time the operator says, what's your emergency? But essentially the question is, why are you calling, right? And then she says, well, I was just attacked and I just want you to know, right? So she doesn't say, well, I have an emergency. She says, I was attacked and I want I want to report it. I'm telling you, agent of the police, that this attack occurred. What about that makes this an emergency?
You're looking at both the 911 operator statements and the respondent statements. And as the Bryant case, the Tyler case, case we cited Petit State versus Petit, the 911 operator is asking questions that are designed to find out what happened, find out what the police are going to face if they go to this location.
So you're,
What
how
additional-
does Michigan versus Bryant help you?
Michigan versus Bryant helps us in several ways. First of all, that was a case like this where frankly, the assailant's location was not known.
So
Michigan
somebody was,
versus Bryant seems nothing like this. I mean, Michigan versus Bryant is the police arriving
the scene.
at the parking lot of a gas station and finding someone who's been shot in the abdomen and is bleeding out and who dies shortly thereafter.
Right. Davis
And
is
in that situation, they're wondering, how did this person get shot and where's the shooter?
where's the shooter
Right.
is exactly
But
the point I was trying to make. We
This,
right now
this is
do
a
not know.
situation where we're a minute into the call where this woman is very calmly reporting her name and address. And then it's, why are you calling? And she is reporting a past attack. I mean, are you saying, I guess I'm sort of wondering, when do we assess the emergency? Are we supposed to assess it as you're walking through it? Or can we look at the call after the fact and say, there was no emergency here?
Whether you're looking at it during the period that the call is being made or assessing it on the drag transcript afterwards, you're looking at what was asked, what was said, and ultimately the primary purpose is illuminated by what is the 911 operator trying to ascertain? Here, he's trying to find out, is there a threat to the public?
oh, see, that's interesting. You think it's, so this goes back to the question I asked of Ms. Beskier, which is, let's say I've been shot, but it was 5 days ago. And I call 911 and I said, I've been shot. Here's a description of who did it. This is their name. Send police. And at no point do I say it was 5 days ago, because I want this to come in. I don't want to testify at trial. And I know my constitutional law. So long as I can, trick this 911 operator into think it's an ongoing emergency, well, then I don't need to come and testify. Do you think that's the right way of thinking about it? It's the operator's purpose in asking questions, even if the person who's making the report knows that there is no emergency?
No, I think that would be first of all, nothing like this case, but second of all, the
I
question
mean,
is.
it's
the
something like
primary
this case,
purpose-
something like this case. She never asks for police to be sent. She never asks for emergency vehicles to be sent. When she's done sort of slowly describing what happened, her statement is, I just wanted to report that.
I have not seen any cases that have required a declarant during a 911 call to ask for police or emergency vehicles or an ambulance. to
I'm
be
not saying that it's a requirement. I'm saying in Davis, the first statements out of the caller's mouth are, he's here beating on me. That's an ongoing emergency, that somebody is here beating on me. This is, something happened. It's about 5-10 minutes ago. It's a type of crime that you would not particularly think the person is coming back. You think they've fled, and she describes them fleeing. Doesn't sound like an ongoing emergency. And the fact that she's not asking for an ambulance and asking for police is some additional support for that. It's not a hard and fast rule. I just want to know, taking all the factors into consideration. I mean, it doesn't look like Davis to me, it doesn't look like Bryant to me. I don't know if you have another case that you want to point me to where that seems like somebody's not even asking for help. They're just calling to report a crime by their own words.
First of all, I do not think that we can hang our hat on whether or not a case is testimonial or non-testimonial by a single phrase that the victim used.
Well, what
I'm
else
just
would
calling
you-
to report that cannot possibly mean that if a 911 call.
I
is
agree.
made and the
Again,
victim
no,
just says that,
I'm
then it's.
not
game over.
I'm not suggesting any hard and fast rule, Ms. Kelly. I would like to know what facts in this call suggest this is an ongoing emergency in a way that reporting any crime isn't something of an ongoing emergency.
I would say three main things. First of all, she does not know where her assailant is. even though she says he's not there or says no, sir, when asked if he's still there. It's clear afterwards that she's saying that when he's asking, well, did he flee on a bike? Which direction did he go? She says, I only saw him coming into the stairwell. So essentially she's saying, I don't know where he is right now.
So it would
She
be, you think it would be,
doesn't know whether
can I
he's
just
armed.
stress test that fact? It would be
Okay.
less of an emergency if she knew he's still in the building or he's in
No,
my
that would
apartment at
still
the
be a
time.
problem. but-
Okay, it would be less of an emergency if she knew he went to his own residence and she gave that address. I don't understand the relevance of this factor yet, so I'm just
I would like
stress
to
testing.
point the court, if I may, to the
Okay.
Smith case. There were three factors. A, the caller didn't know where the person was who had attacked them. B, was not sure whether or not the person was armed. We have that situation here in the 911 call.
Do you think
And
that's a
also we
fair
have a
reading
woman
of the
who's
test?
bleeding.
Do you think that's a fair reading of the testimony? I mean,
I
she's
do,
asked
Your
if he's armed and she says,
I don't know.
he pushed me down the stairs. No, I think she's saying, no, I didn't see a weapon. He pushed me down the stairs. Like if he was going to hold her up at gunpoint, he would have done so, but the weapon that he uses is force. So he pushes her down the stairs.
He said, she definitely said that he threw her down the stairs and hit her in the arms. However, the operator then asked, did he have any weapons? Her response was, I don't know. He threw me down part of the stairs.
But
She's
anyone
not saying
could be
that One
armed,
way or the other.
right? Yeah, but of course, I mean, if the answer is I don't know, then which way you're suggesting that the default is that someone is armed then? Because, I mean, anyone could be armed in the city.
The point is, though, is the question is whether or not the primary purpose is to enable police assistance to meet an ongoing emergency. And you're looking at that objectively from both parties' position and what a reasonable person would think at the time. And I would point again the court to the Smith case because they were saying in Smith that not knowing whether there was a weapon or not weighs in favor of finding non-testimonial. Same thing in Bryant, the shooter's unknown location weighed
But
in
in
favor.
Bryant, there's been a shooting.
We know there's been a shooting. Here we know that there's a bleeding woman who's saying that she was robbed in her stairwell by a stranger who
Okay,
followed
and
her into
she's-
the building and she doesn't
She's
know where he's
asked, do you need medical treatment? And she says, I'm going to clean myself up by myself. I'll be fine.
Right, right.
So
But we still
So
have,
then can we attribute a primary purpose of reporting an emergency to her when she doesn't seem to, she's not calling about the fact that she's been injured. She's calling to report the crime and then she's asked, are you injured? And she says, there's some blood. I've got some abrasions. I'll clean myself up.
But
I'll
we
be
s-
fine.
we
So
still
her
have-
purpose is not to seek medical assistance.
but the potential ongoing emergency does not end simply because the initial victim may have not been so injured that she's saying, oh my God, I need an ambulance. We still have police officers that are going to respond to that scene. We don't know if the guy's still in the building or not based on the 911
So this
call.
gets
and
back
we
to
don't
Judge
know whether
Neal's
he's-
question. Do you think that the police response trumps her disinterest in medical attention?
It's
The fact
all-
that she's being asked if she needs medical services and the fact that an officer will respond to check on her turns this into an emergency? Is
The
that?
case law does not say that a declarant statement trumps the interrogator's questions or anything like that. It's just looking at a totality of the circumstances. I'm not aware of any case law that indicates that what the declarant says outweighs what an objective, reasonable 911 operator would be thinking at the time.
I
Mind
guess
you, this
I'm just-
operator
I'm
then did send a
struggling-
priority one call out for people to come and respond to the scene.
I understand that, but I'm struggling to understand what would differentiate this 911 call from thousands that are made. I mean, is it the fact that it's 5 to 10 minutes after the incident? If she had said exactly the same thing and said it's an hour later, would the government's answer be the same?
That would be a harder case, but right now what we have is
So
somebody who's
it's the
calling.
temporal factor. It's not the substance of what she's saying.
It's both, Your Honor, but what we have here is something that's just happened. We don't know the location of the defendant. We don't know whether or not he's armed, and we know that he is either potentially still in the building. He could have a weapon. He could be on the scene when the police get there. They could be facing danger. And we don't know that since this is a complete stranger who attacked a woman that he followed home from a convenience store because she had money on her. We don't know that he's not going to go out and do that.
I mean,
to
do we
somebody
think
else.
that's likely that he's going to stick around? And that just seems, anyway, can we
E-
go
even
to,
if he is
can we
not
go
gonna
to the
stick
end of the
around.
call? I mean, the end of the call is we're going to send officers to your door. I mean, she's actually confused and says, are they gonna come to my door? And they say, yes, ma'am. And she says, okie dokie, right?
Right.
I mean, it's a
Right.
very
I
odd
don't-
way
I
of
don't see how
reporting an
that makes it
emergency.
Testimonial or non.
Does the government want to talk about harmlessness?
I
beyond a
absolutely
reasonable
want to
doubt?
talk about harmlessness, and it would be harmless under any standard of review. There was very strong evidence here that Austin was the assailant in the stairwell and that he did rob Miss Marvel. First of all, the burglary charge in particular is based on an intent to rob, steal, or assault Marvel. We not only have the injuries that Miss
Can I
Marvel
ask about that?
Certainly.
I don't think that's what the indictment says.
It is, Your Honor.
Where, can you point me to
R44.
where?
It's R44, which I believe may be a superseding indictment. The
Okay,
first-
I was wondering if there was a superseding. I think the initial, the
Yeah, the
jury
initial
was
one
instructed.
was different.
Okay,
Yeah, it's the record at 44 is a superseding indictment, and it was charged with entering with intent to rob, steal, or assault Marvel.
Okay.
So the assault is shown. Ms. Canales testified that she saw the injuries, that Miss Marvel is bleeding. The EMT Pettis saw the injuries. Officer Davis saw the injuries and thought enough of them that he was the one that called to have an EMT present. EMT Pettis said that Marvel told her that she was assaulted in her building hallway. We have, in regard to the assault. with
Did
intent
that
to
come in
rob-
on direct?
I'm sorry, Your
Did
Honor.
that come in on direct?
I believe it did come in on direct examination of EMT. Ms.
And
Pettis.
there was no hearsay objection?
Not that I recall, no, Your Honor. The robbery was shown by the whole incident at the market. The whole thing is on videotape. He's
Well, the
behind her.
intent to rob might be shown from that video, but what's the evidence of the actual robbery that came in
Yeah.
aside from the call?
The evidence of the actual robbery is that in the video of the market that's shot over the back of the counter, you can see Miss Marvel pulling out the green pouch, handing what appears to, I don't know what it appears to be, but it's clear the cashier is going in, pulling out cash, giving it to Miss Marvel, and she's kind of putting it out on the counter, then putting it in that little green see-through change purse. She puts that away. Mr. Austin is just a arm's length away from her, over her shoulder at that time. He then follows her, rides right up behind her, and ultimately, when the police come to the apartment and take a photo of that green see-through change purse, it's empty. There's nothing in it.
Okay.
So
can I, but just, can I get some clarity on one question? Is there any evidence from any witness who says, outside of the 911 call, that Miss Marvel was robbed in that stairwell?
not that she was robbed, but there are certainly statements that Ms. Canales made that would indicate a robbery. For instance, the fact that the groceries are strewn about her, her purse is on the ground when she comes in. So there's been a scuffle. In addition, we have the evidence
Sounds
of Austin's.
sounds
prints on
as
the bag.
consistent with an assault, right?
I'm sorry. Your
That
Honor.
sounds as consistent with an assault as a robbery.
When you add in the fact that you have both left and right hand prints on that bag, the plastic bag that was only touched by the cashier and Miss Marvel, that are three of Mr. Austin's prints, that indicates somebody dumping out the bag.
It
So
might,
looking
it
for-
might. I'm not sure if it's proof beyond a reasonable doubt that she was robbed. And I'm especially not sure that we could say beyond a reasonable doubt that absent the error, a jury would have found proof beyond a reasonable doubt that she was robbed. There's kind of that double beyond a reasonable doubt standard that you have to meet if this is constitutional error, which is a jury. Not just that a jury could have found beyond a reasonable doubt that she was robbed, but that we need to be very certain of that, we ourselves beyond a reasonable doubt, that a jury would have reached that conclusion.
Sure, but when
And-
you look at all the evidence and not just the fingerprints on the outside of the bag, but his only opportunity to do that is in the stairwell. You have the same thing. You have the empty change purse when the police.
Was
take
there
a
an
photo of
actual
it.
photograph exhibit of the change purse
Yes,
as empty?
yes, yes. I'm loath to tell you an exhibit number right now.
Still, and it was-
106 sticks in my mind and I have no idea.
They-
what I
they-
said.
We can find it in the record.
and it was pictured on the stairwell still, as in she
No, it's
was,
pictured on a chair in her
she
apartment.
brought it back up with her? Okay.
Yeah, yeah. So anyway, too, and just the dynamics of when he follows her, he stands there, he's looking at his phone in the corner, and she knows something's up. She looks back at him twice as she's crossing the lobby and slowly going up the stairs. By the time she goes off camera, within 9 seconds, he's already followed her and gone off camera. He gets into the stairwell. He's out of there like a bat out of, you know what? 40 seconds later, there's nobody else that committed this crime. All the evidence is there for assault and robbery. And even if you could say there's
Do we get to look
insufficient
at-
evidence of the robbery, there's certainly with all that evidence, evidence to show that he was assaulting with intent to rob. He's looking for something to steal.
Do we get to look at the videotape evidence of him running away from the scene quickly, as you just alluded to, in thinking about whether or not there's an emergency that's being reported?
No, because you're looking at the call and what the speaker and the 911 operator knew at the time. And Miss Marvel did not know where he went after he left the building, after he left the stairwell. That's just not known to the people that were in the 911 call. So I don't think that that informs the court's decision about that aspect. But it is certainly evidence that he wanted to get out of there quickly. He knew that he had committed this robbery and he needs to get off the scene.
One quick question. We asked your colleague on the other side if she had any case law supporting the notion that defense strategy, changes in defense strategy based on the admission of evidence is a factor in the harmless error analysis. Do you have any case law supporting what I suppose is your argument that it is not?
I would say that it is not. I mean, I do know that saying now on appeal that, oh, we would have done something differently, that the motion was decided before trial. He had ample time to decide what he was going to do at trial.
Yeah,
But-
I think that's her point.
Yeah, it is her point, but you're looking at the trial as it came out. And as I was pointing out at the beginning of my statements here today, was that defense counsel was not bringing out the information about Officer Davis's inability to recall, and then us putting in the fact that his recollection about what Miss Marvel had told him had been refreshed and what the details were. He was doing that to show sloppy police work. He wasn't doing it to say like, oh, gee, there was some nuanced difference between what she told Officer Davis versus what was in the 911 call, for instance. This was a matter of him showing that this was sloppy police work. Not only did they not do their work at the scene to investigate the whole building, they, in his mind, didn't even bother to prepare for trial. And that was the point he was making. At page 127, he said, I wasn't planning to elicit the details of the description that Marvel gave to Davis. What I wanted to do was just show that he didn't remember this stuff. So that's a very calculated decision that isn't about whether the 911 call came in. It goes with his sloppy police work theme, which the jury did not go with. But I don't think, given what the defense counsel said during trial, that one can say that it was because of the 911 call coming in that this is why he chose to elicit Officer Davis's testimony about the description. And so for all those reasons, at the very least, we believe this is harmless error under any standard of review, and we would respectfully request that you affirm the decision of the trial court.
Thank you, Ms. Kelly.
Thank you.
Ms. Baskier, we'll give you just a couple of minutes.
Okay, thank you, Your Honor. I wanted to start with the green change purse to say that first, I'm not sure that the photographic evidence, the photo and evidence, to me, it's hard to tell if it is empty or see-through or not. But even if it is, there's a significant amount of time that passes between when she leaves the store, where we see that she does fumble around rearranging things quite a lot. And when the police come and take a picture of that purse, and it's just purely speculative that somebody else took the money out of it rather than her getting home. And while she's, okay, I'm going to change my shirt before I call 911. I'm going to stop my crying. I'm going to put my money back where I want to keep my money. There are a lot of possible explanations if you don't have the 911 call.
Do we have that picture?
I did not include it
Okay.
in Mr. Austin's limited appendix, and I'm not sure that.
I just didn't recall seeing it. Okay.
Yes, Your Honor. In terms of the what government counsel was just arguing about, the reason for asking these questions was to show sloppy police work. That was the reason that he gave after the 911 call had been heard, after he knew the 911 call was coming in, and is left again making the best of a difficult situation of, okay, I'm going to try to point out any kind of sloppy police work I can. I think it would be unreasonable to expect that he would choose to emphasize sloppy police work in that way if the jury hadn't already heard the 911 call. And I am happy if the court would like to identify some of the other reasons why from the operator's perspective, the call did not appear to be trying to seeking help responding to an ongoing as opposed to a past emergency, if the court would like. But otherwise, since my time is just about up, I would ask that the court reverse Mr. Austin's convictions, either on confrontation or hearsay rules, and find that the harm to him was prejudicial as to all counts, and therefore to reverse those convictions. Thank you.
Thank you, Ms. Basquiat. Thank you again, Ms. Kelly. The case will be submitted. The second case on our calendar today is 23CO11. Sean Henney versus the United States. Go ahead and take a minute, council, to get squared away. We had a little bit of a changeover, so.
Good morning, Your Honor. Brayshawn Dozier, and on behalf of Mr. Sean Henney, I would like to reserve 2 minutes for rebuttal. Thank you, and may it please the court. In its decision below, the trial court recognized that this was an exceedingly close case where the majority of the IRA factors weighed in favor of Mr. Henney's release. The court agreed that Mr. Henney's history and childhood trauma weighed in favor of release. The court found that he had a, quote, robust entry plan, that he had completed a, quote, impressive 900+ hours in educational and vocational programming, and that he has served as a mentor to other inmates and has been, quote, a positive influence on his friends and his family. The court's decision denying relief thus entirely turned on the court's understanding of 2 incidents. One was a 2016 disciplinary infraction for the possession of a dangerous weapon, and 2 was a physical altercation in 2021 between Mr. Henney and his cellmate. In analyzing those 2 incidents, however, the court committed reversible error. The court erred when it disregarded the key piece of evidence regarding those 2 incidents, and that is expert testimony from Ms. Maureen Baird, a former BOP warden who worked at the Bureau of Prisons for 30 years, who interpreted those prison records about those 2 particular incidents and explained that they illustrate that Mr. Henney was not only not violent or an aggressor, but that as it pertained to the 2016 incident, due to the dangerousness of that particular U.S. penitentiary that he was in, it was, quote, common for all USP inmates to carry weapons for self-defense purposes.
Counsel, so you said disregarded, and I think a lot turns on how we interpret that word. I mean, you can disregard something by, I mean, the court could have excluded the testimony and the evidence altogether. The court could have said, I decline to consider this at all. Or the court could have given it little weight compared to other factors. And it seems to me like the court did the last thing that I just mentioned. So why is that reversible error in your view?
Yes, Your Honor. So to your first point, the court did not formally exclude her as an expert. But the issue here is that in the court's written order, there's absolutely no reference whatsoever to the substance of Ms. Baird's testimony.
Well, not specifically, but the court does allude to post hoc reports,
Sure.
right? And I think the court
Sure.
is talking about the Baird report. So why isn't this like what Judge Schenker asked about, sort of the court alluding to post hoc reports and saying, I'm not giving that very much weight, so I'm not going to talk about it.
Sure. So to address your first point, it is not sufficient for the court to merely state that Ms. Baird testified or that her testimony was a mere post hoc analysis. And on that basis, it appears that the court, because it categorized Ms. Baird's testimony as post hoc, did not consider it. And I'm turning to the order at page 11, where the court specifically says that because Ms. Baird's testimony was post hoc and that post hoc evaluative assessments, quote, may vary, the only facts before the court, those facts on which subsequent opinions are based, deeply concern the court.
Right, well,
So it's not that.
Can I
I'm sorry.
just unpack what I think that statement means, and you can tell me
Sure.
if you disagree? This is not a general reason for denying or rejecting Ms. Baird's testimony. He's talking in the context of the 2021 assaults on a cellmate. So as to that incident, this really is a post hoc report. It is an explanation that was fed to Ms. Baird by Mr. Henney that he did not offer contemporaneously with the assaults, which seems like a pretty cogent reason to discredit the statement. He's saying, what I think what the judge is saying is, well, this is one explanation. It's not the one that Henney gave at the time. I've got these disciplinary infraction findings that are at odds with it. And that's the better evidence because it's contemporaneous. And to the extent Baird says anything that's dependent on his post hoc rationalizations, I mean, give me a break. That's a Johnny come lately explanation, and I'm not going to credit that. That all, what's wrong with that?
Sure, Your Honor. So the primary issue with that is that post hoc analysis, just dismissing her expert testimony on the basis that it is post hoc, is legal error because all expert testimony is post hoc.
Oh, sure. But I'm giving a very specific way in which it's post hoc. So I want to make sure I understand your answer. As to her testimony about what happened at the 2021 incident, could a trial judge not conclude, well, that's all based on Mr. Henney's like self-serving testimony a year after the fact, and it's post hoc rationalizations that he's been fed? You know, if we were really just talking about the 2021 assault, is it error to say, well, I'm not going to credit this expert's testimony about that because she wasn't there and she's being fed a story?
Sure. So first of all, Ms. Baird's testimony was not contingent upon things that were told to her by Mr. Henney. She was interpreting those same records that the court is relying upon. So when she gave her expert testimony, it was an interpretation of those very facts that you mentioned. And then the court, in categorizing that as post hoc and therefore not subject to consideration, erred because, again, we know that expert testimony is very crucial for understanding prior facts that occurred or understanding the underlying facts or the giving context to what happened.
What do
So
you
on
mean?
that sole basis, I'm sorry.
What do you mean that she's interpreting the same facts? I mean, the facts are facts, right?
Sure.
That you've got the fact that the fight happened. So what interpretation
So
or other expert opinion did she offer?
sure. So she was providing context to the 2021 incident in particular and the 2016. In the 2021 incident, she testified that it is prison custom that when an inmate is processed at these U.S. penitentiaries, that they have 30 days to submit paperwork to prove that they are not either a rapist, a child molester, or an informant. And in Mr. Henney's particular case, his cellmate, his 30 days were coming up and he had yet to submit his paperwork. And often, and this is according to Ms. Baird's testimony in her familiarity with prison custom, having been awarded for 7 years at a similar U.S. penitentiary, is that when inmates don't have their paperwork in and they want to be removed from the compound because they're not safe to walk, because they haven't proven that they haven't done the horrid things I mentioned, they often initiate fights in order to be isolated so they don't have to walk the compound.
I mean, that all seems to say Mr. Henney's version of what happened is plausible enough. Like that's what Baird's testimony is about the 2021 assault. Yeah, that's a plausible reason why somebody might pick a fight. Sure. Ms. Baird isn't there. She doesn't know what happened. And why isn't it perfectly reasonable for a judge to say, we have contemporaneous findings from BOP officials. Mr. Henney had some due process. He was offered the opportunity to explain what happened, and he didn't come up with any of this. And so why on earth would Ms. Baird carry dispositive weight as to what happened in 2021? Now, you might be saying something different, which is a great deal of Ms. Baird's report has nothing to do with that 2021 assault. So discarding that out of hand based on post hoc rationalizations, that would be an error. That I think might have some legs. But it doesn't make any sense to me to say a trial judge couldn't say Ms. Baird wasn't there at this assault. There's plenty of reason to think Mr. Henney's lying about it. All she can say is he offers a plausible enough reason for why somebody might have assaulted him, but he didn't offer it at the time, and so I'm not going to credit that. That all just seems incredibly reasonable to me, and so I'm not getting I'm not being moved by your argument.
So, Your Honor, even if, let's say we were to concede that what you say is correct, that the judge believed deep down that Ms. Baer's testimony was not credible because she was not there and she's just giving a explanation of the underlying facts that occurred. Even so, if we look at the requirement of the IRA statute to issue a written opinion stating the reasons for denying relief, the key evidence here, and we've established this, was the 2021 and 2016 incidents. Everything that you just described, the trial judge said nothing about in his court order. The only thing he said in the entire order was that it is post hoc and that it won't be considered. That's the only thing he said regarding the substance of Ms. Baer's testimony. And that itself is where the error lies, because if you're just going to say that's post hoc, it doesn't matter, then the statute has no teeth, because the statute requires the defendant to be able to give a statement regarding what occurred, which he did. And then once the judge permitted the evidence, he was required to consider that evidence.
Well,
So
the
even-
judge in a written order explained what the court explained what it considered in reaching its conclusion. I mean, I guess is your argument that, and do you have case law supporting the notion that, let's take us outside of the IRA context, unless your argument is that this is strictly within the IRA context under the statute, but let's say we have a medical malpractice case. If a court says, I'm going to allow both sides to present expert testimony because under the rules of evidence, they generally have a right to, but then it's in an order, it says, look, I've been around long enough to know that both sides can get a medical expert to say whatever they want them to say. So I never give that any weight. I mean, do we have any case law saying that that's automatically reversible error?
So in that particular context, no, but I will point to the DC Circuit case, United States v. White, where a defendant presented mitigating evidence, and then the court concluded that because that evidence was not explicitly referenced in the opinion, that there was error. And that is a similar situation we have here. So we're left, because the trial judge only stated that the evidence was post hoc and that it wouldn't be considered, he didn't give any explanation of why he wasn't crediting it. He didn't give any explanation concerning what Judge Deal was saying about the fact that, she wasn't there. All he said was that it's post hoc and it can't be considered.
He does give that explanation. He says, we have contemporaneous reports. We have BOP disciplinary findings that are contemporaneous. Those are the facts before the court. I just don't know what more somebody could say, which is, yes, Ms. Baird gives an explanation of what might have happened, but here are what the facts that were developed at the time through a hearing where he had a chance to present his side of the story, and I'm going to go with that. I mean, that's pretty sound rationale, I think.
So again, Your Honor, I'll point to the United States v. White case in that even if the judge, and this is also a requirement under the IRA statute, even if the judge comes to your conclusion, he is required under the IRA statute to issue a written opinion explaining that. The judge here only has one sentence where he says he did not consider it because it was post hoc. There's no discussion of credibility. There is no discussion of all the things that you just mentioned. And again, if there was some other reason, Your Honor, even if we were to concede, okay, maybe he dismissed it for another purpose, many of the ones that Your Honor just brought up before me, he was required to write about it under the statute, which he did not do.
Facts solicited at the motions hearing, including those in relatively contemporaneous records before the court, establish a violent encounter and are less consistent with Mr. Henney being an innocent participant than with him being at least a co-aggressor. That seems to explicitly address which version the trial judge is crediting. It then leads into the post hoc evaluative assessments may vary.
Which is our key point, Your Honor. So if his purpose for discrediting Ms. Baird was that it was post hoc, that itself is error, because again, all expert testimony.
Yeah, but that seems like a very uncharitable way of reading what the trial court is saying. What the trial court is saying is, I've got contemporaneous findings and reports and records, and I don't care about the post hoc stuff so much, because in this context, when I have contemporaneous findings, those are going to win out. I agree with you. If somebody were to announce a sort of across the board rule that I don't consider post hoc expert assessments,
Sure.
that would be error that we would readily reverse. It seems like a very strange view to attribute to a trial judge who, in this context, is saying, I have contemporaneous findings from the BOP. Mr. Henney didn't offer a contemporaneous explanation. That all seems totally sensible to me.
So again, if we're in agreement that the 2021 and 2016 incidents were the key evidence in this case, And then we're in agreement. Let's say I agree with you that the trial.
Actually,
judge thinks- I'm sorry.
can I just pause right there?
Yes.
It's curious to me that you keep saying that. Does not seem to be a very good thing for you to stress. I would agree with you that the 2021 and 2016 incidents were the key basis for the trial court denying
Sure.
relief here. But I think what you might want to say is taking those incidents into account, even if properly discrediting the expert, there was a whole lot of other evidence the expert was giving about why these are consistent with substantial compliance with the disciplinary, with BOP regulations. You know, the expert says, you know, this is a low number of disciplinary infractions during his 8 years in BOP. 3 of them are like nuisance type infractions. And so these are the only 2 you've got to hang your hat on. And she says, these are pretty commonplace. And look at everything else. He's moved to medium security prison, which is unheard of for lifers, is roughly what Baird says. He is trusted to be a referee in basketball games, which they let, you know, people who are considered mentors do that. There's all sorts of evidence in Baird's report that is not accounted for by the trial court. And I wonder why we're not leaning on that a little bit more than trying to focus our attention on the 2021 assault, which is unquestionably bad for your client, no matter how you slice it.
So the reason why, Your Honor, is because we are specifically focused on the error that took place at the hearing itself. Because the trial judge does, throughout his order, quote to the record of the things that you were mentioning and that you outlined. The issue that we have is that based on what happened at the hearing, there is no indication in his order that he considered any of the information that Ms. Baird, and I'm talking about the substance, not the information already in the record, the substance of what Ms. Baird testified to. And on top of that, Your Honor, I would
But
just
isn't,
add,
I'm
sorry.
I'm a little bit confused. Isn't her expert opinion about how to evaluate his record and his security level and the fact that he's moved to a different facility so soon after the 2021 incident, isn't that important information that isn't in the order?
Sure, absolutely, Your Honor. And our issue with it is that he didn't mention any of the evidence. The reason why we're focusing on the 2021 and 2016 is
So
because
that
was-
information can't be fairly described as a post hoc evaluative assessment, right? When the expert is saying, hey, this is hugely unusual that he gets moved to a low security facility 6 months after a fight. That's significant. That tells you something about what BOP thinks about him, right?
Sure.
That's not a post hoc evaluative assessment. That's expert insight onto how BOP sees him as a prisoner.
Sure, but based on the court's order, the trial judge did categorize that as post hoc. That would not be considered. He states specifically that.
And
the
you're
only
saying
fact-
that is wrong.
Yes, that is wrong because
Okay.
one, post hoc evaluative assessments may vary. That's what he stated. Then he states that the only facts that were to be considered were the underlying prison records. The reason why that is error is because, again, expert testimony is always post hoc. And if that's based on that logic, then no expert testimony would ever be admitted in any case. And then, Your Honor, if there was some other reason besides the fact that it was post hoc, like Judge Adil was saying, why the trial court discredited Ms. Baird's testimony, the trial judge was required to give that reason in the written order under the statute because this was the key evidence on which the case turned. And this court in United States v. Williams talked about that when it said that it is extremely critical for the trial judge to issue a written opinion explaining the bases for denying because it allows this court and ensures that this court can conduct effective appellate review without any explanation besides the fact that it's post hoc, because that's the only explanation we have in the order. Without any other explanation as to why Ms. Baird's testimony was discredited, this court cannot conduct effective appellate review because virtually the trial judge has left Your Honors nothing to review in terms of why Ms. Baird's testimony was specifically disregarded or discredited. And if the reason why it was disregarded or discredited is that it's post hoc, that is wrong. So either way, we can't get around the error here. It's either wrong in saying that it's post hoc because all expert testimony is post hoc, or it's wrong that it's some other reason that they didn't write down, which was in violation of the IRA statute that requires them to issue a written opinion going to the key evidence of what dictated the outcome in this case.
Okay, thank
And
you,
obviously,
counsel.
I'll-
I think we have your argument and we're going to let you get up after the government, but
Thank
I'll
you.
let you sit down for right now. Thank you.
May it please the court, Ann Park on behalf of the United States. The trial court did not abuse its discretion in denying Mr. Henney's IRAA motion. Judge Ryan carefully considered all the evidence submitted by the parties and the relevant IRAA factors and reasonably concluded the appellant did not pose a danger to the community and that the interests of justice did not warrant a sentence reduction. Appellant's argument really boils down to he disagrees with the weight and the balancing of the weight of the evidence that Judge Ryan the weight he placed on the evidence as well as at the balancing of the factors, and that's just not grounds for reversal. This court gives the trial judge a lot of discretion in how to weigh the evidence and balance.
Well, we can, so
factors.
counsel, we can call something weight, but would you say that if a trial judge, and I'm not saying that's what happened here, but if a trial judge came in, let's just stick with IRA cases and said, it's weight, but I always give expert testimony on BOP prison situations, 0 weight, because I don't believe in it, or it's post hoc, or whatever you want to call it, that is okay?
No, Your Honor, because I think if trial court comes out and says, I have a carte blanche rule I apply all the time, that exactly is what discretion is. You look at each case individually, look at all the evidence and the factors individually, and you weigh it. When you give a blanket rule that you use to cover all cases, that is, I think, by definition, an abuse of discretion. You're not exercising that discretion, but that is definitely not what happened here. And page 11 of his order, he's talking specifically about the February 2021 incident. And nowhere in the order is there any indication that he's saying Ms. Baird's testimony was some sort of post hoc evaluation. She's looking back at the records and making an opinion. So I'm not going to consider it because it's a post hoc evaluation. That's simply not what the order says.
So I agree with you that I think that's the best reading of his order. But nowhere else does he say one word about Baird's expert testimony, which is strange to, I mean, please correct me, but let me just complete the thought.
Sure.
It's strange to me that if you're going to hang your hat on denying release on 2 disciplinary infractions, that one would seem to disregard an expert on, I see a lot of these cases. Sometimes there's 40 infractions, sometimes there's 10, sometimes they're serious, sometimes they're not. I don't think trial court judges or us are very expert at interpreting what those infractions mean toward future dangerousness. There are pattern scores that are good at doing that, but we're not very good at doing that. So I think you're about to tell me where you think Judge Ryan actually considered Baird's expert report elsewhere. But if I disagree with you, isn't that a very big omission from his analysis?
No, Your Honor. And what I'm going to point out is very small because he definitely does not.
He references it, right?
Yes,
At
yes,
the beginning.
Yes, at the very beginning. And he specifically says, I'm considering the motions hearing at which these 3 people testified, including Maureen Baird. And he held a hearing, she testified. He states that he considered her testimony where she repeats a lot of her opinion she makes in her report. It's hard to think that he didn't consider it. And when
For sure. I mean, I agree that, he mentions it. It's definitely in the background, but there's a statutory question, whether or not this is substantial compliance with the VOP regulations, disciplinary. I forget the rest of the statutory language. There's one expert in this case, and really only one piece of evidence whether or not this disciplinary history amounts to substantial compliance. And that's Baird saying, yes, this is pretty good. You look at, 5 infractions in 8 years, 3 of which are nuisance type infractions. This is better than most. He's a 1 in 100 in terms of lifers being moved down to medium security, basically unheard of. This is roughly what her testimony says. So if you considered it, doesn't it cry out for some reconciliation? I agree that a trial court could say, I've heard that, but she's a hired gun and I don't buy it. All right, I don't find her credible. That would be one thing. But he doesn't say anything about it. And that seems like something that is just begging for the trial court to address in this analysis.
Your Honor, I would say Judge Ryan went through each factor very carefully. And he also he said he reviewed the disciplinary reports. He basically looked at everything Ms. Baird looked at, and he reached a completely different conclusion from her. We know what her testimony was. He's not a danger. She would release him if she had the chance. And, he substantially complied with all the rules of the institution in context, and the court came exactly opposite. So I think the only thing this court can reasonably infer from that is he considered her opinion and he rejected it. And he also didn't just, he's talked about why these infractions gave him great pause. He talked about the context.
How do we, if that is subject to some sort of abuse of discretion review, how do we review that if we have no idea? You're saying it's implicit that he rejected this expert testimony.
Yes, Your Honor.
We have no idea why, right? We have no idea whether he just thought she was a hired gun, just testifying for the money, or whether he just didn't think it was persuasive for some other reason. Like we have no idea why he didn't consider this other information that she provided that, he admits her as an expert, right? And says, yeah, you are qualified to testify about how infractions are viewed by BOP. And then he doesn't explain why he doesn't.
But he does go through every
consider, yeah, I guess I could say, sure, he rejects it, but I have no idea why.
Well, he rejects it because he goes through the disciplinary reports and also explains his reasons for the weight he puts on the evidence. So you can see his reasons for rejecting her ultimate opinion. I think this gets down to, defense counsel bringing up the statutory requirement under IRA that the court issued a written order. And I think the danger of trying to say you have to include everything, every piece of evidence, you have to talk about every little thing, is you're really gonna, defense counsel could look at that and say, oh, they didn't mention this important fact, and so you violated IRA, which I think it's subsection B4, the court shall issue an opinion in writing stating the reasons for granting or denying the application under this section. And Judge Ryan wrote an 18-page order. He went through each of the factors.
Well, you keep saying
evidence.
he went through each of the factors.
Yes.
But if you look at the third factor, substantial compliance with the rules of the institution, right? He talks about the 2016 and 2021 incidents. Does he talk about the fact that Mr. Henney was then moved to a medium security facility shortly after the 2021 incident in that discussion?
No, he does not talk about
No.
that fact at all. No,
Right.
but he does
And
say
that was significant
well,
to Ms. Baird, right? She
that-
said that really puts these two infractions in context
yes, Your Honor.
and shows that within the BOP's thinking, and I am testifying as an expert who knows how the BOP's thinks, this just wasn't a big deal. And so for the court then to write an order where it says, look at these two incidents, they're such a big deal, and not to mention her testimony about the subsequent transfer, not to grapple with why it's not persuasive. I'm not sure what we're supposed to do with that. Either the court forgot about it, which is not acceptable, or the court didn't tell us why it found it unpersuasive. And so I can't review that for an abuse of discretion.
Your Honor, but you can, because even though he didn't specifically mention those facts, he does say that those incidents, because of their violent nature and their recency, caused him great pause. So he is saying that these incidents are, and he had the entire disciplinary record before him. I think the appellant also testified that he was sent to a medium security prison and that it was actually suspended his sentence. So he had all that information in front of him. I think you can reasonably infer that that portion of the evidence was not given weight. He was looking at he calls the sheer volume of his prior disciplinary record in New Jersey. Was it New Jersey? In Virginia. Virginia. And then also the two most recent ones. And he was looking at the violent nature of those. He found that the defendant was the aggressor. And it's clear by implication that he did not give weight to that evidence.
He did not find that the appellant was the aggressor.
The co-aggressor.
I mean,
not
yeah, it
the
was-
victim.
Yeah, I mean, but part of, what would you say if he had one disciplinary infraction on his record and it was disobeying an order, being in a restricted area, something like that. And the judge says, and he gets a report like Baird's that says, you know, typically for somebody who's been in BOP custody for 8 years, you're expecting 20 such infractions. This guy only has one. And the judge says, no, I don't think that's substantial compliance. In my view, you break a rule, and release is out of the question. Would you think that might be an abuse of discretion, or do you think trial judges just can say that?
Your Honor,
I'm
I don't
just-
want to say it would be an abuse of discretion, but the infraction is disobeying a rule, and that's the only thing in his 8 years, and you're assuming there's no 41 prior, that's the only single infraction.
Right.
I think it'd be hard. If there's nothing violent, or it doesn't indicate that he's a danger to the community, and the court can't articulate why that one particular disciplinary infraction is so bad that,
Fighting with the cellmate, I mean, I've got to say, I don't have instincts on sort of how indicative that is of somebody's dangerousness. If you told me anybody who's serving even 5 years is going to get in a physical altercation with a cellmate eventually, I believe that. Baird says something kind of like that. You're sharing a cell with somebody, and you don't always get to pick who that, I mean, you never get to pick who that person is. And so eventually you're going to run into somebody who is just a violent person and they might want to fight you. So you either put up your dukes and you fight back, or you get beaten into a pulp
But I
and then
think-
you're a target, right? I'm sorry, if you have,
I think the key here is, with regard to the particular facts, is that he did the right thing at first. He went out, he made a distress call, they took him to the showers, they brought him back in, and he immediately, according to the disciplinary reports, which Judge Ryan credited, he immediately begins to start to fight. We kind of reset the clock, and he begins the fight.
right.
And I think that is what concerned Judge Ryan. Also, the fact that he had a 5-inch shank in his shorts while he was refereeing a game. And he testified that during this time, there was a lot of tension going on in his compound. That fact also weighed heavily on Judge Ryan. And it's just not an abuse of discretion for a judge to look at those facts that show some sort of violence, recent violence, and weigh those more heavily. And
Maybe
find that
not
he's a
if there's
danger.
no expert testimony to put them in context. But if there's then expert testimony that says, look, you know, these things happen, right? These things are actually quite common. And looking at his record, he has very few disciplinary infractions, and take note of the fact, and this is highly, highly unusual, you know, within months of this fight in the cell, he is transferred to a medium security facility, which is almost unheard of for a lifer, because we assume that people who are in for life feel like they have nothing to lose, and we usually put them in high security facilities, right? I mean, that just like, that completely changes the picture, I think. And maybe the court would still reach the same conclusion, but we have no idea why the court didn't alter its thinking in light of that evidence.
You know, but I think I think the danger of kind of parsing out these orders, and not allowing the judge to, or requiring that they include everything, is he clearly did not, I think it's reasonable to infer he did not give much weight to Ms. Baird's testimony. He didn't explicitly say it. All his conclusions he drew were exactly the opposite. And I think the danger of saying you have to include and discuss every single piece of evidence is that these orders they'll never,
I certainly, I don't think anybody suggests,
hold up.
I totally agree.
Wow.
I don't think anybody's suggesting that as a rule.
Yeah.
I mean, nobody's faulting him for not discussing each of the statements that were written on behalf of Mr. Henney.
All the statute requires. And
I mean, you know, it's funny. There's not such a clear line in my view, but sometimes things just scream out to be addressed, and sometimes they don't. And in this case, you know, in the pleadings before the trial court, in the reply in favor of release, you know, the one thing that Mr. Henney said is the government hasn't said one word about Baird's report or done anything to try to dissuade you from why she's correct that that this is substantial compliance, that he's not a risk to be let out. So it is very funny when that's the final word on the topic for a trial court to likewise say basically nothing about Baird's report. Now, I take your point. We don't need trial courts to specifically address every single thing. But if you're going to base your judgment on two disciplinary infractions, it does seem that one ought to specifically address the expert testimony that those two infractions are commonplace, really not important when you look at the grand scheme of things, not viewed as being important by the BOP, as you can see from his movement to a lower security. All those things just seem like maybe a trial court could say, no, but I know better. Sure. But you kind of want them to address those, and I'm given some trouble that it wasn't addressed.
I understand, Your Honor, but I think at the end of the day, you give the trial judge a lot of discretion. He does not have to accept expert testimony. We know he was aware of it. We know he considered it. We know by his conclusions that he rejected it. And I think it's not an abuse of discretion for him to not accept the opinion, which is ultimately what his order comes down to.
Can I ask one other question? Maybe a little bit of a curveball, and you're free to remain agnostic on this. Do you think Mr. Henney is eligible for release? For IRA relief?
The original
Because he's
question,
only served 8 years of his the sentence for the underlying offense?
I haven't really looked into it because we conceded it below, so we're bound by that. But I think could be an argument to be made that
Do you think a trial court
Virginia's
judge
Virginia.
could consider that in the interest of justice under factor C11? That he is only 8 years into a sentence for a murder?
You mean?
That, in the interest of.
He could just found on legal grounds that he's not eligible.
Oh, no, yeah, I mean, it's been conceded that he's eligible. But a trial court still think, well, in the interest of justice, he's only 8 years into this sentence, which doesn't seem, it's a very, very, very small fraction and sort of less than what IRA contemplates, because you kind of expect 15 years to have been served. Not quite the case here. It's all curveball. I don't think, like you said, it's been conceded. I don't think this really matters right now in this appeal, but I was just curious about your thoughts.
I think that's a very interesting question. I guess it's how expansive do we read that kind of catch-all provision?
Can I ask you
Seems like a
another
good argument to
curveball?
make.
Sorry. Also not raised here by anybody, but I'm curious about this. If you look at factor 10, there's a last piece of factor 10 that says, and the defendant's personal circumstances that support an aging out of crime. And it doesn't appear that this was part of the amended statute in 2021. And I believe that the proceeding here was after that. And it doesn't appear that the trial court cited that version of factor 10. And I'm not asking you to talk about other cases, but I've seen this 3 times now myself. And I don't know if anything's going on with respect to the trial courts and maybe the government failing to bring and I put the burden on the government, but obviously it's on both sides, to bring the new version of the statute to the court's attention in all of these cases. But do you have any sense of why that was?
No, Your Honor. I mean,
Yes.
Judge Ryan relied on the first half of that factors. That's my
Right.
recollection. And he's basically said it's like a thumbprint on the side of a relief for him without considering that final sentence. I don't know.
Okay, I
why
mean,
it wasn't brought up.
I'm gonna ask you to go back to your office and suggest that the government should, in all of these cases, should be making sure that the trial court's looking at the right version of the statute.
I'll certainly convey that, Your Honor. And you're right, it was not mentioned below this part of the subsection 10. If there are no further questions, I will submit on the brief with regard to the procedural errors, and we respectfully request that the judgment of the Superior Court be affirmed.
Thank you, counsel.
So, Your Honor, one point of contention that was continuously brought up by the government was that Judge Ryan was not required to consider every single piece of evidence. And I just want to make clear to the court that that is not our position. Our position is that he was required to consider this particular evidence because it went directly to exactly why Mr. Henney was denied release, meaning the 2021 and 2016 incidents. So we're not saying they have to consider every single thing, but he does the trial court does have to consider something when that is going to be the basis for denying relief under the statute. And again, you cannot satisfy that statutory written requirement without writing about why this particular piece of evidence was discredited, and he hasn't done that. I also want to address the reasonable inference discussion. We're left here because the judge did not explicitly explain why he may or may not have found Ms. Baird's testimony to be credible. We have to guess or speculate why. And again, that deprives this court of an opportunity to conduct effective appellate review. And in these instances, this court in US v. Williams talks about why that's so important. And then also the DC Circuit in US v. White states, and it was faced with a similar issue, was that because there was nothing in the opinion that gave the indication that this evidence was considered, they had no choice but to remand. And that is the same exact case here. Because we don't know why Ms. Baird's testimony was discredited other than this one sentence in the order that it was post hoc. Because we don't know why, we are left with nothing more but to guess. And this court thus should remand for further proceedings so that the trial court can conduct that consideration of the evidence, and then two, issue an opinion that will explain why he or she discredited or gave credence to that evidence. And I also wanted to address one thing Judge Deal brought up earlier, which was that Mr. Henney was given an opportunity to explain, but he didn't. Ms. Baird also testified to that as well. She stated that after the 2021 incident occurred, Mr. Henney would not have been able to explain why the fight occurred to the guards. And Mr. Henney at his hearing also explained that if he were to do that, the other inmates could bring severe harm to him. So that was spoken to as well. And overall, again, if there's no mention or reference or grappling with any of the substance of the only evidence that was presented at this hearing was Ms. Baird's expert testimony, we cannot be sure, we're only left to guess or speculate that the judge truly considered it. And that itself is error. And if he didn't consider it because it was post hoc, that was error because all expert testimony is post hoc. And if it was some other reason, he was required to write about it, which he did not do. So if there are no further questions, Your Honor, I'll sit back. Thank you.
Thank you, counsel. Case will be submitted. The third case on the calendar today is 23 CM 334 GW versus United States.
Morning, Your Honors. May it please the court, Adrian Madsen on behalf of Appellant GW. I'd like to reserve 3 minutes for rebuttal. GW timely appeals from a judgment of the Criminal Division of the Superior Court. That judgment does not fall within the exception in 11-721C. That is the penalty for the sentence exceeded $50. So this case is properly before this court. GW is also aggrieved by this order in that the conviction remains a conviction for several statutory purposes and additionally available to court personnel and to law enforcement personnel. That is, there is a possibility that legal consequences will flow from the challenged conviction.
Counsel, how much does your argument depend on the fact that an amended judgment J&C was issued following the trial court's order on the set aside? I mean, if the court had just entered an order or a decision on the set aside saying I'm setting aside the 2019 conviction and not issued an amended J&C, what would there be to appeal from here? And I mean, I realize there is an amended J&C, so maybe that's your answer, but how much does your argument depend on that?
Your Honor, I have not fully considered that issue because it's not the issue presented here. That is, GW is appealing from the amended judgment and commitment order, which I'll note that the government consented to the issuance of the amended JNC below. So it is not only waived, but forfeited any argument with respect to the court's ability to do that. But to answer Your Honor's question, we might be in a different circumstance if the court had only imposed an order setting aside the conviction, but not an amended JNC. But that is not the circumstance.
Are you aware that that ever happens?
Your Honor, I have
That
not had
IRA
it.
set
I have
aside
not had it
happen
happen.
just by order, or is it this the typical method is that you issue an amended JNC?
I have not had it happen in a case where the case was previously before this court and remanded for the direct appeal. I have had it happen, again, I understand this is outside the record, but to answer Your Honor's question, I have had it happen where a court has only issued an order and a certificate explaining its decision to set aside the conviction rather than additionally an amended JNC. And I think one of the reasons as a practical matter for that is that in a case where there is probation, but I suppose it would also apply even to a straight time sentence, other authorities are often confused by the issuance of an amended JNC, thinking that the original sentence is again being imposed again. So again, as an example, while this is outside the record here, even despite the language that the trial court included in the amended JNC, in this case, after receiving that, CSOSA inquired of the court how to get in touch with GW because it believed that GW would be on probation. Obviously, that's a misinterpretation of the error, but one of the reasons I believe that doesn't happen as a practical matter is to avoid that confusion.
It's interesting. I would have thought that it worked the other way, where you'd want to have a JNC with your final sentence on it, so you can say, this is the final sentence that I have, and it is a conviction with a YRA set aside, but that's not how it necessarily works in practice.
Right. I think in terms of it as a practical matter, the quality assurance branch doesn't have anything to send to CSOSA, at least not in the form of an amended sentence. And so they think sentence is over, sentence has been completed, whatever happened with the original sentence happened. Whereas if they get an amended JNC, they immediately process this is a new sentence coming, sort of regardless of what it says about the sentence.
So another question that I have for you is, I mean, what if, and I understand this isn't your case, but what if GW had gotten the sentence, had not appealed from his conviction, had then received a YRA set aside, had gotten an amended JNC as he did in this case, and then sought to appeal? Would that be appropriate?
Your Honor, I guess I would respond in a few ways. I don't think that would, it certainly would not deprive this court of jurisdiction under 11-721A1. Depending on the nature of the sentence, assuming it was more than $50, it wouldn't fall within the exception in 11-721C. It would be timely under assuming within 30 days of this court's Rule 4. So there may be other issues that could be presented about that, but I don't think it would deprive this court of
Yes,
jurisdiction.
I mean, I think the government's response would be, well, you're clearly not aggrieved by that order. The conviction, the sentence, the conviction was already in place for some number of years. Like, again, we're assuming in this case that there were no initial appeal. That conviction has been around for a few years. You could imagine a trial court correcting the date on a JNC. I said one thing 3 years ago, and it turned out that I entered this on November 12th instead of November 11th. That's relevant to something, so I'm going to amend the order and enter it anew. In assessing whether or not your client is aggrieved by that order, isn't it sort of the relevant question, well, what's changed? In that case, it would seem to be no basis to be aggrieved because there was a conviction initially and then there's a conviction still 3 years later. In this case, there's a conviction initially. There is the thing that's changed 3 years later is, and now it's set aside. So while I agree that even a set aside conviction one could be aggrieved by that, they're not aggrieved by the set aside itself. They're aggrieved by the still lingering collateral effects of the conviction, which has been in place for several years. What's wrong with thinking of it that way?
So I think this court's decisions addressing the issue of what it means to be aggrieved by something don't focus on whether in the hypothetical that Your Honor gave there, the timing of when the being aggrieved by something occurs other than it being timely. That is, so in the cases the government cites, and I'm not aware of other cases to the contrary, the case in the government cites CT, which is they are examples of either parties or non-parties who don't have rights that are impacted by the order in any way. So that in CT, that was a non-parent trying to appeal a termination of parental rights order. In Briggs, another case the government cites, that was Friend Act counsel appointed as amicus in the trial court. They're not a party, they're not aggrieved by it. And so I don't think there is a case of this court that I'm aware of, and the government has cited none, holding that to be aggrieved by something wouldn't allow for consideration of all the ways in which a party was aggrieved, regardless of whether the judgment that does that might have been the same or similar to a prior judgment that was ordered.
And this might be an unfair question. And I'm trying to remember, I don't think they were discussed in the briefs, but are you familiar with Magwood v. Patterson or Long versus United States out of this court where were those discussed in the briefs? I just don't, I remember thinking they were relevant and that I didn't see them getting as much play in the briefs as I would have thought. Do you think they impact the analysis here if you are familiar?
Long versus United States, I am familiar, and that was cited by the government in this brief here. I don't think that is particularly relevant to the case here. That is in Long, where this court was deciding that whether the new judgment for habeas purposes, that is adopting the majority position that the new judgment allowed him to file an amended J&C, allowed him to file a new 2310, as I recall the facts of Long. I just don't think they are. It's
certainly a little different because it's a collateral proceeding, and Magwood is a habeas proceeding. But my memory is, the Magwood was quite divisive. I think it was a 5-4. That somebody could raise a habeas challenge to their sentence, get relief, sent back for a new judgment that includes a different sentence, or even if it includes the same sentence, I think they can then challenge the underlying conviction, even though nothing's changed about that. And I mean, I think maybe I'm misremembering those cases. I haven't revisited them, but they seem quite friendly to your view that it's really not. Has something changed from point A to point B? It's, entry of a new judgment is entry of a new judgment. But that does run into what strikes me as a very unpalatable result that any YRA set aside that involves an amended judgment could resuscitate an otherwise already exhausted appeal or never taken appeal, which is not your scenario, but it seems bad.
And certainly, the government might take a different position, but I understand the government's position wouldn't be controlling, and the trial court may also take a different position in those circumstances on issuing the amended J&C. The trial court had the background here, the government had the background here, and made those decisions.
But the other bad thing about that is, and again, this is a little unfair to you because it's not where we are in your case, so I'll just leave it at this, but is that it does preclude the argument from people in your client's position that these are collateral proceedings. I mean, Judge Deal just said those cases might be distinguishable because they involve collateral proceedings. I'm not sure why the set aside motions aren't considered collateral proceedings akin to 23-110s or motions for expungement that can't proceed at the same time an appeal in this court can proceed. Because the conviction, I mean, they're not undoing the conviction, which is your whole point as to why this isn't moot. I mean, I don't think anyone argues that this is moot, but
and I would agree that, Your Honor, that the government doesn't argue that it is moot and has waived that argument as indicated in the reply brief. I think that butts up against, which I'm happy to address, to a certain degree, this court's decision in Wilson.
right.
And I think that for several reasons, I think Wilson is wrongly decided and not on point here. But I think.
But that's what probably drove you, if it was you, to move to withdraw the appeal here because of Wilson, I guess, and
In part, Your Honor, and in part, the desire to have GW's conviction properly set aside timely. In many practical respects, in terms of that had already occurred, but in terms of the legal consequences for GW, having that set aside sooner rather than later. Of course, I understand, this court decides its cases as expeditiously as possible, but who knows when there will be a decision in this case. And I do want to go back to Judge Deal, your question. I think there are cases of this court that that address the circumstances, however palatable or not that it may be. In a case cited by the government, Bell versus United States in the brief, it was via Rule 35, but there was a reduction to a more favorable sentence, as has happened here. And Bell, in that case, then appealed from the amended J&C, which included the reduced sentence. And this court reached the merits of the direct appeal. That is the same circumstance that we have here, however palatable that may be or not. But again, Bell had also, as here, had timely appealed in the first instance from the conviction.
And the Rule 35 happened while the appeal was pending?
Yes, so in Bell, the trial
There
court
just
issued.
seems to be a world of difference between a case where an individual has either had a direct appeal or forfeited their right to have an appeal, which has consequences, right? At that point, if you have had your direct appeal or forfeited your direct appeal, then you're in the world of collateral review, right? You got your shot. But your client was in the midst of pursuing his direct appeal and then went back to get the benefit of the set aside, got the amended J&C, and then essentially continued his direct appeal.
Yes, Your Honor, that's correct. And I think Your Honor doesn't need to reach, and this court doesn't need to reach those more difficult questions wherein, as you say, it's a world of difference that is in both Bell and in this case, the appellant timely appealed. It wasn't an issue where the time to appeal had run. There's just this intervening circumstance to obtain a more favorable sentence and then continue with the direct appeal.
Should we talk
We
about the
talk
assault for a minute?
Can we talk about the merits?
Yes, Your Honor. The only thing I wanted to add about Wilson, if I could briefly, before getting to the merits, is a few things. One is, I think this court's statements about mootness in Wilson were simply a function of it not knowing whether Wilson would continue with the direct appeal after the case was remanded. That is, here, GW again has appealed from the amended J&C. That may or may not have happened in Wilson. And so the reason that this court in Wilson was saying that it would normally remand the case and dismiss the appeal as moot was because there may or may not be something for it to decide in the future. The second thing I'll add just about Wilson there is that the YRA, so the Wilson was, at the time that Wilson was decided, there were no statutory purposes codified in the YRA for which a YRA set aside remained a conviction. And so we have a fairly different circumstance here. So even if the Wilson was read to say that a set aside of a conviction under YRA rendered a direct appeal moot, the statute has significantly changed for that time and the purpose for which convictions are properly considered. Or again, as Your Honors seemingly have generally indicated, Wilson may just have been wrongly decided if it was deciding that made that moot. So turning to the merits, I first want to say regarding the issue of the sufficiency of the evidence, GW is in light of the, I don't want to say continued evolution, but continued articulation by this court of different elements of assault where bodily damage doesn't result. GW is withdrawing his concession regarding the sufficiency of the evidence for the simple assault. And turning to the merits, there were I don't think there's any dispute that the fourth or fifth elements, the trial court made no findings regarding simple assault. And as this court's decision last month in Smith makes clear that where there is no bodily damage, and even under the government's version of events here, there was no bodily damage. Where there is no bodily damage and it's a non-sexual touching, and again, no allegation of that here, the elements of Perez-Fernandez as modified by Smith control. So an unintentional but reckless non-sexual offensive touching that causes no bodily damage does not constitute a completed battery assault. And the relevance of that here is that the government's brief, which admittedly was filed before this court's decision in Smith, but seems to suggest that Perez-Fernandez left in place outside of offensive touchings, attempted battery assault with the elements of attempted battery assault as they had been articulated prior to Perez-Fernandez, and that is just not correct.
I'm not sure I understand why. Let me just get some clarity on why you think Smith has changed the calculus. I understand Smith to be a case about the touching itself was unintentional. It is hard to see a universe in which the touching here, the grab of a lapel, the grab of a jacket, this is not swinging an arm, it's not walking backward into somebody, it's not walking forward into somebody. I have never, to my knowledge, accidentally grabbed somebody. And it seems like a very odd thing to even contemplate. So why is Smith changing the calculus for you? I mean, just by virtue of the word grab, you've kind of got an intention in there, right?
Yes, Your Honor. I think the best I can say is that I understand and don't disagree with Your Honor's articulation of the holding of Smith. Is that Smith caused me to, in light of reviewing all of the evidence in this case, caused me to withdraw that concession.
Okay. I just want to separate out two different thoughts though.
Sure.
What one thought is, which I think is what Smith is saying, well, the touching needs to be intentional. In this case, the fight is not really about was the touching intentional. It was sort of, was it intended to be offensive? And there I don't think Smith says the answer is it has to be. I think Smith would still say, well, if it's offensive to a reasonable person, well, let me not wing these factors and try to pull them up.
Your Honor, I think Smith
sure.
says that the touching has to be intentional. It cannot be reckless. That is
Right.
the core holding of.
But not that the offense needs to be intended.
So that is a so taking Perez-Fernandez, that is that the defendant either acted with a purpose of causing offense or acted knowing that the touching would cause offense. I don't think that Smith directly addresses, and this may be an open question, of whether recklessness as to the intent of the touching would suffice.
I thought Perez-Fernandez reserved on that question.
Correct.
Okay, and I don't think Smith
does
answered.
as well. That is, I'm saying
Do you think Smith has answered it, or you don't think Smith has? Okay,
I don't.
Okay,
Yeah, so I think Smith has answered
Got
the fourth prong of Perez-Fernandez. That is that the touching would offend a person's. I'm sorry, that the third prong. That is sorry. I should
okay.
stop.
I get lost. I get lost too.
Sorry, the first prong. That is that the touching needs to be intentional. Recklessness is not sufficient. That is what Smith holds. I think left open is whether recklessness as to the fourth and fifth elements, that is the touching would offend a person's reasonable sense of personal dignity, and that the defendant acted either with a purpose or acted knowing would cause offense, that is left open. And
That's why you're withdrawing your concession and suggesting that a remand is required to
yes,
court to determine
in part, yes, Your Honor. And you know, to Your Honor's question about saying that, you know, a grab might never be intentional, and you thought that the dispute is over whether or not this would cause offense or was intended to cause offense. I just want to say that the GW's position, which has been the case, I understand that we have the trial court's factual findings, but is that there was no touching at all.
Right, that's what really makes the remand particularly strange. The defense is there was no touching. The defense has never been. Now I understand it's a sufficiency question. And so trial courts and juries still need to find elements that are uncontested. You know, caveat Nader versus United States, which is kind of a little exception to that, I think. But it is a little bit odd where the defense was never touched him. So a remand seems a little like a fool's errand that, you know, all the elements as they were understood at the time of an assault have been conceded if he grabbed him. And the trial court just rejected the defense that he never grabbed him.
Two responses.
Uh-huh.
One, Your Honor, the trial court statement, and I don't know if I have the transcript in front of me here, but what the trial court says, the question is only whether he touched him, and that was what that was enough. And so I think that leaves substantial doubt as to whether the trial court would find the elements satisfied here. And the other thing is just, and these are, as I understand, before this court, the trial court's finding that this happened, while it is still reviewed for clear error, notwithstanding the fact that this is on video in light of this court's decisions in TW and Hawkins that have addressed this issue. What this court has said is that it need not go as far as to say that videotape blatantly contradicts a witness testimony, but that this court has not seen evidence to support it. And reviewing the video of this incident, I have not seen, and I invite the court, of course, evidence that supports the trial court's conclusion that the officer moved forward in such a way. So again, we're talking about a very, even as alleged by the government, a very transient contact here that is being inferred by a slight movement of an officer from an MTPD video here. And so, but again, I don't think that finding finds support in the video that is before this court. I see that my time has expired, and I'll reserve the remainder for rebuttal.
Thank you, counsel.
Good morning, Your Honors, and may it please the court, Mark Hobel for the United States. GW's appeal should be dismissed as untimely, and in the alternative, this court should affirm his conviction. I'd like to begin with the timeliness issue and then address assault. I do think on timeliness, Judge Dealey referred to the Long decision in Magwood. There was some reference to Bell as well from Mr. Madsen. These cases are very important, and we did cite them and rely on them in our brief. Long involved a resentencing in which the original sentence was vacated and the case was remanded for resentencing. This court held that in a resentencing, the conviction is vacated and reimposed, and that's what allowed Long to overcome the second or successive bar. That is why an appeal from that order would not be untimely.
I'm sorry, I'm not following, because the appeal in Longwood isn't from the resentencing order. It's from the denial of the 23-110 order. So timeliness wasn't an issue in Long. So if your argument is about timeliness under Rule 4.
Right. And I apologize, Your Honor, I am getting there. The resentencing reimposes. Long is very clear on this. The resentencing reimposes the conviction, and the conviction can be, at that point, can be appealed from under Rule 4 if it's timely. A set aside under the YRA is not a resentence, and I think this is really the crux of the dispute between myself and Mr. Madsen. Hickerson, I would suggest, would be our key authority on the distinction between a resentencing and a set aside. Hickerson involved a statute that the sex offender registration statute that would not recognize a conviction that had been vacated or reversed. In a resentencing, such as in Long, the conviction is vacated in order for the new sentence to be imposed. But Hickerson says the set aside, and that was under a YRA precursor that the YRA was based on, the set aside does not alter the fact of conviction. It's not vacatur or reversal. So our position is that conviction, which was imposed in 2019, years ago, it has remained in an unaltered state. The set aside reflects a policy decision that it should not be able to be used for various reasons. But it is not a resentencing as in Long or Bell. The conviction was never vacated and re-entered. Therefore, the appeal is from the 2019 conviction, which remains in an intact state, and it is very, very, very untimely under Rule 4, which is a mandatory.
Can I just kind of ask why your position makes sense? And part of this goes to, look, there are restrictions on when an appellant can ask us to recall the mandate. We can do it ourselves. And if I really thought that you were right about sort of the technical steps of, he had an initial appeal by virtue of asking for a remand for YRA resentencing, and then filing a new appeal rather than asking to reinstate that prior appeal means that he's abandoned the earlier one, I would think, well, that seems pretty unfair. We can get around that. Let's just reinstate the earlier appeal, sua sponte, recall the mandate. I guess that's going to require them to go back and set the thing aside again after this. But we can do it. We're pretty creative. And in no sense would it comport with any logical purpose of, our court rules to say, where we've remanded for this set aside and you've never had your initial appeal that you filed, it's never been resolved. We're going to find that you've waived it by what amounts to sort of a procedural nicety that you didn't ask, maybe you should have asked for a record remand instead of a case remand. I don't know. I actually don't even know if the single judge order vacating or dismissing the prior appeal is proper. Because there's nothing in our statute that allows a single judge to issue an order dismissing an appeal. Put that aside. Why does this make any sense? And why shouldn't we just reinstate the prior appeal if we agree with you?
I think those all may be fantastic arguments in favor of granting a motion to recall the mandate. But, the proper vehicle here is a motion to recall the mandate. And as the government, we're an institutional litigant and we have a strong interest in procedural regularity. And so I take your point, Your Honor, and I take Judge Easterly's point, and I think in the question that was asked to Mr. Madsen, well, you haven't had that appeal yet, but you haven't had a disposition on your appeal yet. Isn't it more fair to give you that opportunity? And my response to that is simply that is what a motion to recall the mandate is for. And as to whether that satisfies exceptional circumstances is a discretionary call by the court. On the other hand, what GW did here was attempt to file an appeal as of right and claim it was from the set aside order, which he's not aggrieved by, and attempt to sort of bootstrap in an untimely appeal from his conviction.
It makes it sound like you think that he's trying to pull one over on us, and so maybe he messed up procedurally, but he has an amended J&C. Right. I mean, and he is aggrieved by a judgment and a commitment order that says you're convicted of this crime and you have a YRA set aside that has collateral consequences on you, right? As set out in the statute and beyond, right? Because if he still has this conviction, he can't move to seal his arrest, right? Like he wants this gone. He doesn't just want to be released. He would like this conviction erased from his past, which he cannot do unless and until we review his appeal. So I just, under fairness, I like Judge Deal. I'm not seeing what the government is trying to get at or why the government thinks that he's doing something that's so improper.
Not in any improper in a legal sense. I'm certainly not suggesting that anybody is trying. I can't remember the phrase Your Honor used at the beginning there, but no, just that again, there is a mechanism to effectuate everything that Your Honor is talking about. It's a motion to recall the mandate, and as a matter of discretion and basic fairness, if the court were to consider that to be exceptional circumstances, we could disagree, but that's a discretionary call on the part of the court, and there's a standard for that.
So we could make that discretionary call and make that clear in an opinion going forward. If this comes up if your appeal is pending and the law changes in a way that you think is favorable to you, and you're waiting for that to be resolved, but in the meantime, you become eligible for a YRA set aside, what you should do is ask for your appeal to be dismissed and then go back and get your YRA set aside and then come back to us and move to recall the mandate. And so we could lay that all out in this opinion and say that's the proper procedure in this unusual circumstance. Would that be okay?
To clarify the procedure, I think that would be,
Correct.
that would be more than okay. That
All
would be
right,
helpful, Your
and
Honor.
wouldn't you think that GW should get the benefit of that ruling because we're clarifying something that was not procedurally clear prior to us saying that?
I disagree that it was not procedurally clear and therefore he should get the benefit. You know, ultimately, he's, you know, at this point, the time for filing a motion to recall the mandate has passed. I understand Your Honor might suggest, well, you know, it's good cause for failing to follow the 180-day period because the law wasn't clear. But our position is just the law has been clear that a motion to recall the mandate is the proper vehicle for reinstating a conviction. If you look at GW's brief, his opening brief.
Can I just introduce so long as we're kind of talking about technicalities, I have one I want to get your thoughts on. The motion to remand filed, I believe by Mr. Madsen, says upon the trial court setting aside his conviction, Mr. Wright will reinstate his direct appeal. Doesn't cite the vehicle. And then when we issue the order granting the remand, we say, the case is remanded to the Superior Court for further proceedings consistent with the statements made in appellant's motion. If you wanted to get really technical about it, we don't say we haven't affirmed, we haven't reversed. We've said we're adopting what appellant says in his motion. He says he's going to reinstate his appeal. Seems like we've given him prior authorization to reinstate his appeal. What's wrong with looking at it that way?
I disagree with that. The relief was the remand. The court granted the remand. I certainly haven't heard GW argue the point that Your Honor is making, which is that effectively it's law of the case and that we've somehow waived that argument. I'm happy to, unless there are any further questions on the timeliness issue, I am happy to move on to the assault and the elements there. So with respect to the assault elements, and I guess I do have to address the reversal. Our position would be the sufficiency claim is waived. You can't bring a claim for the first time in oral argument, especially one that you've already expressly abandoned. As for Smith was decided on, I believe, December 21st. GW filed his reply brief certainly after Smith was decided and gave.
We asked about Smith. So
Right.
should we give the parties an opportunity to file supplemental briefs?
No, I think the court just ordered us to come prepared to talk about Smith. I think I came prepared, I think the government came prepared to talk about Smith in the context of the instructional error claim. What I'm referring to is just the attempt to sort of revive the abandoned sufficiency claim.
I don't quite understand the government's characterization of this as an instructional error claim. We don't have instructional error claims when you've got a bench trial, right? I mean, I understand sort of the theoretical, the judges instructing themselves, but I thought we made pretty clear in Carroll that you're entitled to a verdict based on the correct elements of crime. And even if the evidence is, if having defined what the correct elements are, we determine that the evidence is sufficient, you're still entitled to the actual fact finder, the trial judge, to issue a verdict based on those correct elements. So I'm not tracking this instructional error line of cases that seems to come from jury trials that I thought we said pretty clearly, and Carroll doesn't apply to this scenario.
Yeah. So, in Lick Laka, the court stated that in a bench trial, the trial court essentially instructs itself. And in Carroll, footnote 5 of Carroll states, we commend the trial court. It's really helpful when trial courts list out the elements that they are applying to assist the parties to assist appellate review. So we do see that an instructional error claim in a bench trial is one, a claim, and two, it is a distinct claim from a sufficiency claim. Carroll says the elements are a necessary and integral part of a sufficiency claim. So when a sufficiency claim is preserved by the MJOA and goes up on appeal, the court necessarily has to look at the elements in conjunction with that sufficiency claim. Here we have sort of I think GW is seeking sort of an extension of Carroll in that the sufficiency claim that was preserved by the MJOA has been abandoned. And he is seeking to juxtapose a totally different claim, the instructional error claim, here for the court. So we would submit that it should be reviewed for plain error, but regardless of the standard of review, there was no error here, and remand is.
Well, how can you say there's no error? I mean, let's put aside all of that stuff, but how can you say there's no error? I mean, that we hadn't articulated the elements of a non-sexual, non-bodily injury assault yet. So necessarily the trial judge didn't consider those elements. And that seems to be error. Now, whether, what we do about that is a different question, but I don't know how the trial judge could have foreseen what we were going to say in Perez Hernandez as modified by Smith, so that the trial court could apply the correct law.
It did apply the elements of attempted battery assault, which we submit, and I think we disagree here with GW. We submit that attempted battery, it remains a viable mode of proving assault. In Perez Hernandez, the court stated, I think it was a heading for a section, there are various forms of assault, and the law recognizes attempted battery, intent to frighten. I always mess these up. Sexual, nonviolent sexual touching assault, and non-sexual offensive.
See, wouldn't it be nice to have a DC code that had all of these crimes listed?
So are you saying this can be both an attempted battery assault and a completed battery assault? I mean, it seems like you're not saying that.
I'm saying that it is an attempted battery assault, and again, the sufficiency challenge is waived here, and it is an attempted battery assault. Whether it could also potentially be an offensive touching assault and fit those elements, I think the answer is probably yes, but it's not necessary to reach that issue here because it is an attempted battery assault. Our best.
I'm sorry, I'm confused, and maybe just because I didn't quite hear the beginning of your exchange with Judge Schenker. So you think that there is now post Smith still daylight between an attempted battery assault and we've said a completed battery assault. I mean, assault doesn't require battery, right? So, but somehow we got into the practice of calling batteries assaults, and we said, that's fine, it's still an assault. So isn't it all, it's just assault? Like it's still an attempted battery assault, even if the battery has been completed, or what am I missing?
It's all an assault. It's
all an attempted battery assault is, I guess, my question, or am I mistaken about that?
I don't think you're mistaken. I'm sorry. I think I don't mean to, I do want to just raise the court's attention. The court may know this already. The red book, the current version of the red book includes instructions for the four types of assault that I listed earlier in separate instructions for each, including, of course, the elements that were delineated from Perez Hernandez for offensive touching. And so obviously the red book is not.
Right. The red book is created off of our case law, and the red book didn't have Smith. So,
right.
Yeah.
In terms of Smith, I do want to address that, just given the court's order. Smith says that recklessness is not sufficient mens rea for an offensive touching without bodily damage. That's not really at issue here because the touching, however way you cut it, if you call it a touching, if you call it a use of force or violence, it was intentional. We would submit that the key authority that supports our position here is the case of Buchanan that we cited. in our brief, Buchanan relied on a case called Williams.
Flailing the arms and throwing the shoes is. I
Right,
believe,
Williams-
Buchanan and Williams respectively.
Right, and they say that the key, the essential element of attempted battery assault committed in that way, which was effectively resisting arrest, is intent to use force or violence against another. It's the targeting.
Right, but we're in Paris Hernandez land now, right? And that's what Smith, I think, makes clear. It says Paris Hernandez isn't just about, you know, non-sexual offensive touchings that offend dignity. Paris Hernandez is actually about attempted battery assaults. I mean, that's, Smith is using the Paris Hernandez framework. So then you have to look to the mens rea elements that Paris Hernandez says you have to use, right? And you have to make sure that the attempted battery or the touching is intentional, right? The action is intentional, either the throwing of the shoe or the poking, right? And then you have to make sure that that there's the intent element to actually offend is also satisfied. And the trial court never considered that in this case. And it seems important in a case where I understand you've got law enforcement officers saying he came after us, but you look at the videotape and you see a young man walking away from a large number of Metro cops who then fall on top of him. And you just can't see what precipitates that. I mean, maybe there was a grab, but you cannot see, and maybe the grab was to prevent him from falling backwards. I mean, we can't see it. And so there's testimony and videotape evidence and no finding on mens rea. So
I in terms of I do think, Your Honor, the ship has sailed as to one, whether there is a grab, and two, whether the grab was intentional rather than accidental. I think even in his brief, GW, when
not whether it was intentional or accidental, but what the purpose
Right.
of the grab was.
Mhm. Right, I given the evidence.
Or what the knowledge was, right? Like, because we say knowledge or purpose in Paris Hernandez, knowledge that you were going to offend or purpose to offend.
Right.
So what was the purpose of the grab?
I think the purpose of the grab, given that the evidence was that the officer repeatedly instructed him, let go, and he GW refused to do so. The purpose was to resist the citation. Again, I'll note that you know, the defense here was that this never happened. The grab never happened. This was just some rationalization for the use of force that the officers had made up after the fact. So, you know, that wasn't really the point of contention at trial, but the intentional use of force or violence against the officer, putting him in the zone of harm, creating, in his words, a safety issue for him, was the crux of this offense. I would note it doesn't seem, from our perspective, it doesn't seem to like it could be the case that Perez Hernandez offensive touching elements cover the waterfront, so to speak, of all assaults, because you still need to have attempted battery assaults, and the offense elements of Perez Hernandez all go to a completed battery. So there still does need to be some room for attempted battery, and we would submit that
You think there needs to be less intent for an attempted battery than more?
I think that the
I would
intent,
think that's sort of the opposite.
right, I don't,
Less in the way of mens rea. Intent is such a vague word, so I apologize.
I just think based on the instructions that are, and again, I am reverting to the red book here, and I recognize, you know, that comes with some peril, but both the attempted battery instruction and the offensive touching instruction both do require some intent. And again, in the fact situation here, that is clearly the law when it comes to an attempted battery in these circumstances under Buchanan and Williams. So we think it's the same. We don't see it as articulated in exactly the same way with the offensiveness and so forth. But in terms of intent or knowledge being significant here rather than being, you know, accidental, we do, one, it's not an issue at this case, but we do see them as roughly analogous.
Can we, I know Mr. Madsen didn't talk about it, but can we quickly talk about the Rule 16 issue? Is the government representing that the jacket actually was disclosed or given to the defense? I mean, I assume that the government has records, so you would know that if the jacket was turned over.
I'm not aware of any record that suggests that the jacket was turned over.
Okay. And if defense counsel had said immediately after the officer testified, my jacket was ripped, wait a second, we never got the jacket, would the government agree that the government should go look for the jacket under Rule 16 if it didn't already have it in its possession? I mean, obviously it's in the government's constructive possession because it's the officer's jacket and he's an agent of the government. So I'm just curious about that.
That sounds like a Rule 16 objection or claim that Your Honor has articulated.
Right, that's what I'm saying. If that objection had been timely made, would the government agree that under Rule 16 it had an obligation to, if it didn't have the jacket, to go look for it and to produce the jacket?
Under the circumstance, I wouldn't contest that under the circumstances here. I mean, I would note if that had happened, that the government might have produced the jacket might have been ripped and we might have put it in evidence and strengthened our case. So, ultimately there
might have been another objection that it hadn't been timely produced, but okay. I just wanted to get clarity on that.
Well, I don't have anything further. We would ask the court to dismiss or in the alternative to affirm. Thank you.
Your Honor, starting with what the elements of simple assault are, I think the government, there is not an attempted battery as existed before Perez Hernandez that remains, or if there is, it is nonetheless controlled by Smith. From Smith, we have, for several reasons, we hold that an intentional touching is required in cases where, as in Perez Hernandez and this case, the defendant's conduct caused no physical damage to the complainant's bodies, so that the conduct would constitute criminal assault solely by virtue of the offensive nature of the touching. There's no dispute that in this case, there's certainly no evidence of bodily damage to the officer.
But you don't think that Smith says that the offense needs to be intended? I don't read Smith to say that, and I'm wondering if you do.
So
I think
Smith doesn't answer.
Okay.
But it does incorporate Perez Hernandez, which requires the offensive action to have been taken with some mens rea, knowledge, purpose, perhaps recklessness.
Correct. And I'm sorry, if that wasn't clear, my statement is I don't think Smith answers whether recklessness would suffice in terms of whether purpose, knowledge.
Take an example. Let's say, we have somebody from a very affectionate culture, I don't know, Basque country. I don't know who's so affectionate, but they come over here. Apologies to any of the Basque in the audience or watching. And they just like to hug and kiss everybody that they see. It's just their way. They kiss people on the lips. They don't mean offense. But they've been told that's pretty offensive. And they say, no, I don't buy that. It's not. So they should know. They're acting in reckless disregard of it being offensive, and they just kiss everybody that they see. Smith neither Smith nor Perez Hernandez would say that can't be an assault. Because the offense isn't intended. They leave recklessness open, right?
So I think Smith says, and Perez Hernandez.
It's an intentional touching in my hypothetical. Again, no accidental kisses in my hypothetical.
Sure. Whether that would be practically certain that the consequence would result, I think is in terms of offensiveness, I think is a fact question. That is, the degree to, in Your Honor's hypothetical, the person had been informed by somebody, this is going to be offensive, whether that rise to the level of practically certain. I don't know, but again, it's a fact question. A few points
So can I just ask if it's right that, the evidence of grabbing here was a grab in contravention of a let go of me, and really no contrary evidence other than no grab happened. Is that not at least reckless. Nobody likes being grabbed. And when somebody's being told and let go of me, well, then you know that they don't like being grabbed. And why, when the evidence is that bit of it, when the only dispute is whether or not that happened at all, and we have a finding that it happened, why isn't it kind of fait accompli that if we were to remand as you request, we already know what the trial court's going to say?
So whether that would offend, to be more precise, that whether that would offend a person's reasonable sense of personal dignity, it's not just this individual officer, right? We have
Right.
objective tests. This court has certainly treated officers differently in other contexts. That is, for example, in the context of threats. I don't have the year before me, but I wasn't thinking about this hypothetical, but this court has certainly treated officers differently in terms of what they should be how they should perceive actions of non-officers. And so I think whether that would rise to the level of that an officer that would offend a reasonable officer's personal sense of dignity, I don't think is so clear. And I believe it was Judge Easterly mentioned in terms of supposing that there was a grab, the reason that there was a grab could have been to steady himself. There are certainly other conceivable reasons here that are consistent with the evidence was. In the video evidence, we have GW backing up, if the purpose was to offend the officer or with knowledge that it would offend the officer, GW's backing up would certainly be inconsistent with that, right? He is trying to avoid confrontation. GW is trying to avoid confrontation with the officer. The government, I just want to say that the government mentioned at the beginning of its argument, Hickerson, in saying that this is not a resentencing and therefore that no amended J&C should have been issued. The government, again, has forfeited that argument. The government consented in the trial court to the issuance of not only of the order setting aside the conviction, but to the amended J&C. Where the government and I agree certainly is that, and I agree that a motion to recall the mandate certainly would be another vehicle, but that does not resolve the issues that are presented in this appeal. And I agree it would be helpful for this court to articulate the proper means of reinstituting a direct appeal in the case where the trial court has indicated a desire to set aside the conviction under the YRA. Last point. The government has said that the sufficiency claim is abandoned. I would just direct on the authority for the ability to withdraw the concession. I would direct the court to Wilkinson versus Austin, which is 545 US 209. Other courts have pointed to that, recognizing the ability to withdraw a concession, including an oral argument. I would also direct this court to its own decisions in one of the many FOP cases, which is at 143 Atlantic 3rd, 768, note 3 about the ability to withdraw a concession, and also to 1836 South Street versus the State of B battle, which is 965 Atlantic 2nd, 832 on the ability to withdraw the concession.
Counsel, can I ask you one question on the Rule 16 question?
Yes, absolutely.
Judge Easterly posed a situation where defense counsel had immediately requested under Rule 16 production of the jacket once the officer testified on cross-examination. If the government had responded then, we don't have the jacket, what would have been the sanction?
So I think there could have been a wide variety of sanctions. That is the three that the court would consider, of course, under the familiar standard are the importance of the evidence loss, the degree or negligence or bad faith. I think the court might have a duty to conduct further inquiry as to why it's not available, and then listening to the evidence that is in terms of the third Rule 16 factor to come to a decision that is, I believe, just under the circumstances. And that certainly could have included a missing evidence instruction, which in closing argument is what GW's argument implicitly amounted to. That is, this evidence is not here, and it would have been unfavorable to the government. And so where the trial, it was not, the trial court seemed to view and said as much in its findings that the jacket, it said, you know, this is a red herring, this is beside the point. But I think the trial court would have had a very different view. One, if there had been a jacket with no tear, or two, if the court had been inferring that there was a jacket with no tear. It was directly to the officer's credibility. The trial court itself has said, look, we have all the video we need except for these few seconds. So I think there could have been a very strong
I
sanction.
mean, I guess the sanction, the most, or a severe sanction would have been assuming that the officer testified untruthfully about the tear in the jacket. And it seems like that's essentially what the trial court did. I mean, I guess you're saying that's not the same as what the trial court did, but.
I don't think that's what the trial court did. The trial court said, this is beside the point. The trial court didn't say, I'm assuming that it wouldn't have been torn. The trial court viewed that, and sort of repeatedly throughout the trial, including intruding on GW's cross-examination at times, the trial court viewed that as not relevant. So I don't think what the trial court did was to say that it was assuming that it was, and I think if it had, that would have been, as Your Honor says, that would have been a very different circumstance.
But one pretty potent sanction that really might have been, I mean, I understand there are stronger ones, but one pretty potent one would have been, Your Honor, disregard the testimony that the jacket was ripped. And that you basically got, you eventually kind of got to. The trial court said, I'm not considering that. I don't care about that. So I mean, when we're talking about the Rule 16 violation, I can agree with you that it's a violation. The trial court might have noted that, but absent some request for a particular type of curative measure, I fail to see how we could say, well, plainly the curative measure that was needed here was sort of an adverse credibility inference against the officer, which I agree with you is stronger than just disregarding it. And I agree with you, might have swayed the trial. But how could that be a plain error?
So two things. One, Your Honor, so GW's position is that through the closing argument, which this court has relied on in other cases at times to find issues preserved, Parsons versus United States, which I'm happy to provide the citation
Yeah,
for.
but the closing argument doesn't say anything about Rule 16. So let's just assume that this is not.
Certainly.
preserved. Yeah.
So the understood. The facts of this case so squarely presented the two necessary findings for either a missing evidence instruction or an adverse credibility finding. That is that the evidence was peculiarly within the party, the other party against who the sanction was requested, and that it would have elucidated the transaction at issue. And I think that is, it would be difficult for the trial court not to recognize that. And so that is the reason why I would submit it was plain error. If there are no further questions, I would ask either that the court vacate GW's conviction or remand for further findings.
Thank you, counsel. We appreciate your time here today, and this case will be submitted.
Thank you.
All right. This honorable court is now adjourned. Exactly.
Good to see you. Good to see you. Have you guys assigned cases by subject matter? It occurred to me that we have few cases together, so I wonder.
Oh, yeah, actually, I actually just got assigned the salt one that you recently fell behind.
Oh, yeah, yeah.
Yeah, that got assigned.